Hello, hello. My lord, may I have your lordship's permission, my lord? May I have your lordship's permission, my lord?
Settlement, when do you want, sir? Wait, when do you want?
Ma'am, knowledge, my lord, one matter.
Sir, one moment, sir, I'll get back to you.
I'm sorry, my lord.
Why? Huh? Oh, so what, Monday? Monday, sir. Monday, take adjournment there. All fresh matters on Monday. Yavattu, sir? What were you doing all these days, sir? What were you doing all these days? Give it, yes. I am not responsible for you keeping quiet, sir. Judgment ನಾಳೆ ಅಂದ್ರಿ ಅಲ್ಲಿ ಹೇಳಿ ಮಂಡೇ ಬರುತ್ತೆ ಮಂಡೇ ಕೊಡಿ all fresh matters on Monday only, please give it, don't wait for anything. All fresh matters on Monday. Settlement whenever you want, you give it, we'll take it. All give. What is your problem? Why are you here again? How matter, madam? Yourdo 14%. ರಿಪೋರ್ಟಿಂಗ್ ಸೆಟಲ್ಮೆಂಟ್ ಬರ್ಕೊಡಿ ಸರ್, ಯಾವತ್ತು ಬೇಕು ಅವತ್ತು ಬರುತ್ತೆ. ಆಯ್ತು ಕೊಡಿ. ಆಯ್ತು ಮೇಡಮ್, 2:30 ಪಾರ್ಟೀಸ್ ಪ್ರೆಸೆಂಟ್. ಅದು NBW issued. Why? FLW husband. Monday, yes. All Monday. Okay. Monday, give it. Fresh matter, pending matter. According to the year set will come, give it.
In the vacation.
Pending matter.
Vacation court will be.
Vacation court date ಕೊಟ್ಟಿರೋದು ನಾನು ಯಾವುದು ತಗೊಳ್ಳಲ್ಲ, ಕೊಡಿ. Yes. So what? Important matter. Monday.
On submission, Lordship. In this case, Lordship, this Honorable Court is already stay the matter, Your Honor. But unfortunately, charge sheet is already filed and the court is also issued the summons and my client is also, stay is there, Your Honor. With this stay is also tomorrow. Tomorrow, ma'am.
ಅದು ಅವರು ಮೂವ್ ಮಾಡಿದ್ದಾರೆ, ಕೊಡಿ. Friday.
My lord, say RFA matter, my lord, 2011.
Friday. Parted matters ಎಲ್ಲ Friday.
My lord,
Pending matters memo ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ.
My lord,
Give all the memos of pending matters. They won't come except according to their seniority on the designated days.
my lord, this is the matter pertaining. Atrocity case has been reached.
ಏನಾರು ಆಗ್ಲಿ ಕೊಡಿ. Nothing. ಒಂದು ವರ್ಷದಿಂದ ಸುಮ್ಮನೆ ಇದ್ರೆ ಈಗ ಅರ್ಜೆನ್ಸಿನ ಎಲ್ಲದು ಕೊಡಿ.
My lord, tomorrow.
No sir, no tomorrows. Pending matters ಎಲ್ಲ ಆ ಡೇಸ್ ಪ್ರಕಾರ ಬರುತ್ತೆ, ಕೊಡಿ.
My lord, this is.
Fresh matter ಅಂದ್ರೆ Monday.
Lord, this is.
In view of the
Maybe whatever it is, ಕೊಡಿ ಸರ್. ಏನು ಅರೆಸ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರಾ?
Yes, madam.
ಯಾಕೆ?
In view of the bail ಸಿಗ್ತಾ ಇಲ್ಲ ಸುಮ್ಮನೆ.
ಬೇಲ್ ಸಿಗ್ತಲ್ಲ ಅಂತ 482 ನಾ? ಇಲ್ವೇ ಇಲ್ಲ. Monday.
Special court is not.
Monday sir.
not
My lord,
sitting,
No
madam.
sir.
354D, my lords, in this matter, is an police constable from past 3 years due to pendency of the criminal petition.
Whom have you stopped sir? Monday ಕೊಡಿ. Fresh matter ಎಲ್ಲ Mondayಗೆ ಕೊಡಿ.
Fresh, it's old matter.
Old matter ಅಂದ್ರೆ ಅದು ಯಾವ ವರ್ಷದ್ದು?
23, my lords.
23 Tuesday ಬರುತ್ತೆ.
No service benefit.
Tuesday 23, Wednesday 24, Thursday 25. Monday all fresh matters. Don't disturb this pattern. Give it. Yes.
Date may be fixed on any date.
It will come sir according to seniority on those days. No preference.
From 3 years, he is not getting any
ಏನ್
service
ಮಾಡಕ್ಕಾಗಲ್ಲ
benefits, my lord. He's police
Can't
constable.
help sir.
La colleague wife.
Can't help sir.
Colleague wife.
I say I am helpless. I want to follow some method. I will follow some method. Yes. 1 year ಇಂದ urgency ಇರ್ಲಿ ಮೂವ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
On last occasion before lordship, I moved the memo.
ಅಲ್ಲ
my lord.
ಯಾಕೆ 1 ವರ್ಷ ನಾನು ಇರ್ಲಿಲ್ವಲ್ಲ ಇದ್ರಲ್ಲಿ ಯಾವ ಮೂವ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು?
I have moved the memo, my lord.
ಮತ್ತೆ
but it
ಯಾಕೆ
has been not
ತಗೊಂಡಿಲ್ಲ?
listed. I have-
ಇದೇ urgency ಯಾವಾಗ ಪ್ರೊಜೆಕ್ಟ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು?
On the last occasion when I moved
ಎಲ್ಲ
the same
ಬೇಡ
memo before
ಬರುತ್ತೆ ಬಿಡಿ.
lordship, my lord.
Yes. Now I have seen how you will trouble me ಅಂತ. Yes, leave it. So I won't get trouble this time. It will come according to seniority. Give it. Yes.
My lord, a false complaint has been.
ಎಲ್ಲ false complaint fresh or pending?
Tabs of
Fresh or pending? Monday. ಫೈನಲ್ ಡಿಸ್ಪೋಸಲ್ ಯಾಕೆ ಸರ್? ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೇಕಾ ಏನು? ಸರಿ, ಫ್ರೈಡೆಗೆ ಹಾಕಿ ಮೇಡಮ್. ನಾಳೆಗೆ ಹಾಕಿ. ಫ್ರೆಶ್ ಆರ್ ಪೆಂಡಿಂಗ್? ಮಂಡೇ.
My lordship.
ಮಂಡೇ. ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ? ಮಂಡೇ.
My lordship.
ನೋ ಸರ್, ಮಂಡೇ. ಏನ್ ಚಾರ್ಜ್ ಇದೆ? ಯಾವತ್ತು ಚಾರ್ಜ್ ಫ್ರೇಮ್? ನೀವು ಪೆಟಿಷನ್ ಮುಂಚೆನೆ ಹಾಕಿದ್ರಲ್ಲ, ತೊಂದರೆ ಇಲ್ಲ ಬಿಡಿ. ಮಂಡೇ ಏನಾಗಲ್ಲ ಸರ್. ಮಂಡೇ ಫ್ರೇಮ್ ಮಾಡ್ಲಿ ಬಿಡಿ. ಪೆಟಿಷನ್ ಮುಂಚೆ ಹಾಕಿದಿರಲ್ವಾ? ಸರಿ, ಪರವಾಗಿಲ್ಲ.
To report settlement. my
ಕೊಡಿ.
lordship.
ಮಂಡೇನೇ ಎಲ್ಲ. ಮಂಡೇ, ಫ್ರೈಡೆ. All parted matters on Friday.
Madam.
Withdrawal. ತಗೊಳ್ಳಿ.
Small submission, Your Honor.
ಕೊಟ್ಬಿಡಿ ಮೆಮೊ. Why are you still waiting? I don't understand. Fresh matters ಎಲ್ಲ ಮಂಡೇ ಕೊಡಿ.
Lords, to report
Fresh
settlement. my lord.
report settlement please give. Fresh matters ಎಲ್ಲ ಮಂಡೇಗೆ give it. ಮಂಡೇ ಸರ್. ಪೆಂಡಿಂಗ್ ಕೊಡಿ ಅದು. ನಿಮ್ಗೆ ಯಾಕೆ ಪ್ರಿಫರೆನ್ಸ್ ಕೊಡ್ಬೇಕು? ಏನ್ ಅರ್ಜೆನ್ಸಿ?
Now they are pretending the Malad, all the new proposal, Malad, saying that Malad, they.
ಇಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
Interim order is that Malad.
give it. ಸುಮ್ನೆ ಇವೆಲ್ಲ ಆಡ್ಬೇಡಿ, ಕೊಡಿ. No sir, give it. If you want, give it. I will take it after 4 weeks. Which year is that? 24. 4 weeks ಬಿಟ್ಟು ಬರುತ್ತೆ. 4 weeks ಬಿಟ್ಟು ಬರುತ್ತೆ.
Pending, my lord, but notice not issued, my lord.
Give it sir.
Lord's a small submission.
Notice not issued ಎಲ್ಲ ಮಂಡೇ ಬರುತ್ತೆ, ಕೊಡಿ.
To report settlement, my lords. It may be
Report
posted
settlement,
tomorrow,
give
my
it.
lords, please.
Yes.
Madam, ಅದು Monday ಹೇಳಿದ್ರು, notice not.
ಧಾರವಾಡ ಬೆಂಚ್ ಏನಾಗಿದೆ? ಪರ್ವಲ್ ಎಕ್ಸ್ಚೇಂಜ್ ಫೈಲ್ ಬಂದಿದ್ರೆ ಮಾತ್ರ. ಅದು ಫ್ರೈಡೆಗೆ ಹಾಕಿ ಮಾಡಿ.
In this case, you are already, madam.
What's the matter? Fresh or pending? Don't argue the matter at this Monday.
My lord, repetition GMCPC for extension of time, my lord.
Friday. Monday. Fresh or Monday? Wait.
Fresh matter, my lord.
ಎಲ್ಲ ಕೊಡಿ, ಫ್ರೆಶ್ ಮಾಡಿ. ಯಾಕೆ ಕಾಯ್ತಾ ಇದ್ದೀರಾ?
Senior citizen, my lord.
So what, ಕೊಡಿ.
70 years of age.
ಪರವಾಗಿಲ್ಲ.
About
Monday.
5 civil matters going on, my lord.
No problem. 3 days ಅಲ್ಲಿ 80 ಆಗಲ್ಲ, ಕೊಡಿ. Yes. Give it.
This date given, madam, pending,
By whom?
previous question.
Give it, yes. Fresh or
Fresh ಅಲ್ಲ.
pending ಬರುತ್ತೆ ಬಿಡಿ.
ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಇವತ್ತು
Give it,
ಡೇಟ್
give
ಇದೆ
it.
ಲಿಸ್ಟ್ ಆಗ್ಲಿಲ್ಲ.
ಕೊಡಿ ಸರ್. ಇವತ್ತಿದೆಯಾ?
ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗ್ಲಿಲ್ಲ.
ಪರವಾಗಿಲ್ಲ.
Date.
ಕೊಡಿ. ಯಾವ ವರ್ಷದ ದಿನ ಪ್ರಕಾರ ಬರುತ್ತೆ. Interim order is there, pending matter. Which year? Move after 4 weeks. Yes.
Pending matter of 24, my lord. POCSO proceedings against me have been deferred. I am respondent number
Give
2.
it. Vacating interim orders ಎಲ್ಲ ಕೊಡಿ. ಕೊಡಿ ಸರ್. ಅದ್ರ ಪಾರ್ಟ್ ಸೀನಿಯಾರಿಟಿ ಪ್ರಕಾರ ಬರುತ್ತೆ, ಕೊಡಿ ಸರ್. ನೋ interim order. Better come. So what? Give it sir. 100 years 100 years ಆಗಿದೆಯಾ? ಕೊಡಿ. ಸುಮ್ಮನೆ ಇವೆಲ್ಲ ಯಾಕೆ? No problem sir. Which year is that? It will come on Thursday. Give it please. Date given, ನಾನು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಾ? Give it sir. No sir. Give it, yes. Yesterday moved the matter is not come? Yes madam, why? ಅಲ್ಲ ನೆನ್ನೆ ಮೂವ್ ಮಾಡಿದ್ದು ಪಾರ್ಟ್ ಹಿಡಿದು ಚೆಕ್ ಮಾಡಿ ನಾಳೆ ಪೋಸ್ಟ್ ಮಾಡಿಸಿ ಅದು. Give it. Where? No problem, give it. Argument ಮಾಡಿ ಅಲ್ಲಿ. ಯಾವ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ? Which year sir? Thursday it will come. Give it, yes. Give it, sir. No problem, sir. Everybody are above 75 years old. Give it. Yenagalla, sir. Nothing is going to happen. 482, even at the later stage, will do it. Yes. What is that?
This is posted tomorrow. The judge is insisting the presence of the petitioners who is not here, who is in Germany under the Factories Act, my
2:30.
lord.
Yes.
It may be posted tomorrow, my lord.
Or
The
tomorrow?
senior is
Yes, tomorrow. Yes, call the case.
Being spoken to still number 1.
Request. May I request? Serial number 72.
Adjournment. ಯಾಕೆ?
One short adjournment.
One shot ಅಲ್ಲಿ adjournment ಕೊಡಕ್ಕಾಗಲ್ಲ. ಬರ್ಲಿ ಇಲ್ಲಿ ಕರ್ದಕ್. Yes.
Serial number 50.
The mention when it is called. Yes.
Being spoken to still number 1.
The petition.
ನಿಮ್ದೇನ್ ಮತ್ತೆ?
Masking of personal information.
ಪರ್ಸನಲ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಯಾವ್ದ್ರದ್ದು?
Numbers ಎಲ್ಲ statement ಅಲ್ಲಿ.
ಫೋನ್ ನಂಬರ್ಸ್ ಎಲ್ಲ?
Name, phone numbers.
ಏನಾಯ್ತು?
Online ಅಲ್ಲಿ ಸರ್ಚ್ ಮಾಡಿದ್ರೆ ಪಾಪ್ ಅಪ್ ಆಗ್ತಾ ಇದೆ ಎಲ್ಲ.
ಏನ್ ನಿಮ್ದಾ?
ಹೌದು. Judgment ಆಗಿದೆ.
ಅದು ನಾ ಏನ್ ಮಾಡ್ಲಿ ಅದಕ್ಕೆ?
ಫಾರ್ ಮಾಸ್ಕಿಂಗ್.
ಮಾಸ್ಕಿಂಗ್ ಕೊಡಿ. ಆಯ್ತು ಕೊಟ್ಟಿರಿ ಅದು. ಫ್ರೈಡೆ.
Admission still number 2.
ಇದೇನು ಅಲ್ಲ ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಯಾರಿಲ್ವಾ? ಅವ್ರೇನ ಇದು? ಏ ನಿಮ್ ಯುವರ್ 14%?
14%.
ಕುಲಕರ್ಣಿ ಶ್ರೀನಾಥ್ ಯಾರು?
Already there is a council, but he has appeared on in person.
ವೈ?
Council.
ಕೌನ್ಸಿಲ್ ಇದಾರೆ ತಾನೆ ಯಾರು?
ಇದಾರೆ ಸ್ವಾಮಿ.
Why did you appear?
He is out of station.
Did you seek permission of the court? ನೀವು 14% ಅಪೇರ್ ಆಗಿದೆ ಅದು ಓಕೆ.
ಸಿ ಫಾರ್ಮ್ ಇದೆ ಸ್ವಾಮಿ.
ಹಾ?
ಸಿ ಫಾರ್ಮ್ ಇದೆ.
ಇದೆ. ಈ ಅಡ್ವೊಕೇಟ್ ವಕಾಲತ್ ಹಾಕಿದ್ಮೇಲೆ ಅದು ಹೋಯ್ತು. Don't do all this. Don't act smart. Yes. ನೀವೇನ ಅಡ್ವೊಕೇಟ್ ಅಂತ ರೆಕಾರ್ಡ್?
Kindly give the date, my lord. The next time.
ಯಾವುದಕ್ಕೆ ಡೇಟ್ ಸರ್? Let your advocate come and ask. Yes. Yes, next.
Still number 2.
Appear for the.
Charge sheet has been filed in 2023.
No stay ಅಲ್ಲ?
There is
No representation ಯಾವಾಗ್ಲೂ. ಬಂದೇ ಇಲ್ಲ ಕೋರ್ಟ್ ಬಂದು.
Last date of in the last hearing, the matter was called at 2:30. Heavy rain was there.
Who called 2:30?
In the last date of hearing, the matter was at 2:30. By the time I reached, there is a heavy rain.
ಅದಕ್ಕೆ ಬೈ ದ ಟೈಮ್ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ ಈಗ.
ಇಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಅದು ಮುಂಚೆನೇ ಆಗಿದ್ದಾರೆ ಸರ್.
ಮುಂಚೆನೆ ಹಾಕಿದಾರ?
ಮುಂಚೆನೇ ಆಗಿದ್ದಾರೆ.
ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ ಇಲ್ಲಿ? ಸಿಸಿನೇ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು.
ಸಿಸಿನೇ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು ಸರ್. We have challenged charge sheet itself. After registering the complaint, she has left India. She is enjoying in Germany. She left India.
ಮತ್ತೆ ಎಂಟ್ರಿ ಮಾಡ್ರಿಲ್ಲ?
ಎಂಟ್ರಿ ಮಾಡಲ್ಲ ಸರ್.
ಹಸ್ಬೆಂಡ್.
ಹಸ್ಬೆಂಡ್.
ಅದರ್ 498.
ನಮಗೆ
There is no any
complainant is not represented. First time ಬರ್ತಾ ಇರೋದು. Learned additional SPP is directed to accept notice for the respondent. The emergent notice to the second respondent returnable by ಹೆಂಗ್ ಸರ್ವ್ ಮಾಡ್ತೀರಾ?
ಹ್ಯಾಂಡ್ ಸಬ್ಮಿಟ್ ಆಗಿದೆ ಸರ್.
ಜರ್ಮನಿ.
ಅಲ್ಲ ಅವ್ರ ಮನೆಗೆ ಇದು ಮಾಡ್ತೀವಿ ಸರ್.
The second respondent complainant be served emergent notice to the second respondent complainant. The petition is preferred. What stage ಅಲ್ಲಿ ಇದೆ ಈಗ?
ಅದೇ ಚಾರ್ಜ್ ಇದೆ ಸರ್. ಚಾರ್ಜ್
ಯಾವತ್ತಿದೆ? Where is the order sheet?
23rd.
Where is the order sheet? 23 ಅಲ್ಲಿ petition ಹಾಕಿ 26 ಅಲ್ಲಿ first time ಬರ್ತಾ ಇದೆ. Where is the order sheet?
23rd ಆಗಿ ಬರುತ್ತೆ ಸರ್.
Where is the order sheet?
I will produce.
Produce the order sheet. List on Monday in the fresh matters.
give a copy because in our copy it's only
Copy
apparent in challenged and
the petitioner shall serve the entire set of papers upon the learned additional SPP. Yes.
Number 3.
ಸುಮ್ನೆ ಕಾಟಾಚಾರಕ್ಕೆ ಹಾಕೋದು, ಸುಮ್ನೆ ಬಿಡೋದು. ಹೌದಾ? ಸರಿ.
ಇದು she has filed a false complaint.
ಅವ್ರ ಕಾಟಾಚಾರಕ್ಕೆಲ್ಲ ಹಾಕೋದು ಹೇಳಿದ್ ನೀವು ಪೆಟಿಷನ್ ಹಾಕಿರೋದು. ಮೂವ್ ಮಾಡಕ್ 3 ವರ್ಷ ಬೇಕಾ? Yes, Monday fresh matters list. Produce the entire order sheet.
Yes sir.
Number 3.
correspondent list.
Yes, sir. What is this?
I challenge the order passed on 143A application.
And
3.1 will be
20%.
infructuous, my lord. 3.1 will be infructuous, my lord.
Okay.
The trial court has passed the final order, my lord.
Kodi.
Trial court convicted
3.1.
there.
There is no representation on behalf of the petitioner. Counsel for the respondent complainant submits that criminal petition 14 of 2023 is rendered infructuous as it arises out of CC 13805 of 2020, and the concerned court has already passed and already rendered its judgment, finding the petitioner guilty of the offences. Therefore, leaving open all the remedy available in law, the petition stands disposed. 313 ಏನು?
Same connected matter. That matter is
ಅದ್ರಲ್ಲಿ
pending.
ಆಗಿಲ್ವಾ ಇನ್ನು?
ಅದರಿಂದ pending. Recall application file ಮಾಡಿದ್ರು, so ಅದರಿಂದ pending. Evidence.
ಅದರಲ್ಲಿ there is no representation by of the petitioner. List after 4 weeks.
Okay.
Before,
ಅದ್ರಲ್ಲಿ ನೀವೇ ತಗೊಳ್ಳಿ, ನೋಟಿಸ್ ತಗೊಳ್ಳಿ ಅದರಲ್ಲಿ. Learned counsel Sridhara K accepts notice for the respondent complainant. There is no representation on behalf of the petitioner. List after 4 weeks. Yes.
For respondent to complainant, my lords, in this case.
I am petitions.
Yes, sir.
I have filed statement of objections.
Copy has not been served.
Objections, the
Objection package.
My lord, this court, my lord, in the similar circumstances, my lord, in respect of the same parties, my lord, quashed the proceedings.
Kodi.
Proceedings. And
but to the same parties.
The complainant, all or the complainants alleging that I am the marketing agent and the accused number 1 is the owner, has sold the property.
Complainant is different.
It is complainant. And then the
Yes, sir.
same police.
My lords, this what
The
has
police
happened
same
is
body.
he has entered into an agreement to sell with my client. Yes, my lords, but the facts are different in this.
Even different.
He has entered into an agreement to sell. I have produced it.
What's the matter, sir?
I have produced it along with my statement of
What is your complaint about?
complaint is that he has induced me to file enter into an agreement to
Induced?
sell.
Why?
He has floated this project called some castle.
You are castle, some castle alla.
Your castle, and he has entered into an agreement to sell, receiving the consideration, my lords.
How much
There-
consideration?
We have paid about,
Amali sold it to someone else?
prior to entering into my sale, into agreement with me, there is a sale deed by the first accused in favor of third party, my lords. This has been concealed by the
Yes, sir.
petitioner and the.
That copy has not been produced, my lord. Actually, the only statement of objection. I am not aware. I am not entered into any agreement as such, my lord, as contended.
ಇವ್ರ ಜೊತೆ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ?
ನಾನು ಇವ್ರ ಜೊತೆ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಂಡಿಲ್ಲ. ಆ ಓನರೇ ಬೇರೆ. ಆಮೇಲೆ ನಾನು ಸೆಕೆಂಡ್ ಅಕ್ಯೂಸ್, ನಾನು ಮಾರ್ಕೆಟಿಂಗ್ ಅಷ್ಟೇ ನಂದು.
You are accused number 2.
Yes, my lord. I am a marketing agent. I am not the owner of the property, my lord.
Kindly peruse the agreement to sell.
Page.
Page 7 along with my statement of objections. Ascent Properties proprietor having.
1 moment. Ascent Properties.
Ashok
Proprietorship firm, proprietor Ashok Reddy.
Please, my lords. There, the representation is that he has formed a residential layout by formulating a scheme.
Copy, please, sir. Copy.
ಎಷ್ಟು ಇಸ್ಕೊಂಡ್ರು ಅವತ್ತು?
ಅವತ್ತು ಅವರು.
What was the consideration?
Total consideration was 8,55,000. I have paid 2,13,000. Entire consideration.
ಇಲ್ಲ 2,13,000 you have paid by check.
Please, my lord.
ಇನ್ ಮಿಕ್ಕಿದ್ದು?
ಅದಾದ್ಮೇಲೆ ಸೇಲ್ ಡೀಡ್ ಆಗಿದೆ ಮೈ ಫೇವರ್.
ನಿಮ್ ಜೊತೆ? Where is the sale deed?
Sale deed is produced by the.
ಇದು agreement of sale ಕೊಟ್ಟಿದ್ದೀರಾ?
Petitioner himself at page number
65.
65. Page number ಇಲ್ಲ
65.
P. Raghavendra.
ನೀವ್ ಯಾರು?
ನಾನು
Praveen Singh Rajpur. Who are you?
I am the purchaser in this.
Where is your name?
85, my lord. 85. What they call?
Page?
Page 85, my lord.
85.
P. Ravindra, the first accused, executes the registered sale deed.
1 minute, sir. 85.
Yes, my lord.
Absolute sale deed.
Yes, P. Ravindra executes the registered
in
sale
favor
deed.
of the present.
Yes.
Please, ma'am.
He is the
P.
proprietor.
Ravindra, in what capacity
My
does he
lord, he is the
execute?
proprietor as well as the developer, my lord.
Ashok Reddy is witness.
You are witness to this, is it?
Yes, my lord. I witnessed to the sale deed. Your lordship would get it at the page.
Witness as what?
Only witness, my lord, not as a consulting
Andre,
witness.
on what capacity are you a witness?
98 only.
Ashok Reddy is witness.
Yes, my lord.
How did you enter into an agreement then?
My lord, the copy has not been given, my lord. Only the objections has been given. I have to check with my client. And therefore, my lord, I'm a
Consideration
dark.
is the same.
Consideration is the same.
8,55,000.
The petitioner is said to have hoodwinked the second respondent complainant as he enters into an agreement of sale with the complainant on 31st January 2012 of a particular property which was already a subject matter of sale prior to the petitioner entering into an agreement with the complainant. The learned counsel for the petitioner submits that in identical cases, the coordinate bench of this court has quashed the proceedings on the score that he is only an agent and ground mele?
Marketing agent.
That the petitioner is only a marketing agent and is not in the capacity of entering into an agreement or executing a sale deed in anybody's favor. But the agreement of sale now produced by the respondent complainant would speak otherwise, as the petitioner is the signatory to the agreement of sale. The petitioner is taken by surprise as he is not aware of the said document, would seek time to secure instructions and make his submissions on the said issue. List next Tuesday in the same stage. Adidra, I'm going to dismiss it. I'll distinguish that judgment.
No, I have nothing to say.
Yes.
The copy be served, my lord.
Kudi yake?
Objections matra copy.
ಅದೇ ಕೋರ್ಟ್ ಕೊಡೋದು ಅವ್ರು ಕೊಡಲ್ಲ ಅಲ್ಲೇ ಡಿಫೆನ್ಸ್ ಸೀಕ್ರೆಟಾ ಎಸ್
Number 5. My lords, the appeal for petitioner 2, 3 and 4. Senior has been engaged in this matter. He's out of
So
station.
what? He should be here. What's the matter?
My lords, it's a 482 matter.
ಅಯ್ಯೋ ಆಮೇಲೆ
Senior has been engaged, my lords. He's out
ಆಮೇಲೆ
of
anything
station.
else you know? 482 matter, senior has been engaged. Beyond that?
My lords, may I please seek any other date? In
No,
the
I will
second
not
week or
grant.
third week?
It is listed for making submissions. Yes. What's the matter, Jagdish sir?
The association, the cooperative society has filed a complaint. Register of cooperative society filed a complaint.
Entry matter ಇದೆಯಾ?
ಇಲ್ಲ entry ಮಾಡಿ.
Entry matter ಇಲ್ಲ. There was no representation on behalf of the petitioners on 2 occasions. Even today, the council seeks adjournment on the score that the senior counsel engaged has some inconvenience. The matter is of the year, the crime is of the year 2019 and is still languishing in this court through the subject petition. Therefore, list the matter after 8 weeks. The pendency of this petition will not come in the way of any further proceedings before the concerned court. Yes. Next.
Number 6.
6. Charge sheet has been filed.
A petitioner in this case, my lords.
Charge sheet ಹಾಕಿದಾರಾ?
They have also filed the discharge application before the trial court. my lords.
ಅಲ್ಲ, that is not a bar for 482, but charge sheet ಹಾಕಿದ್ರೆ charge sheet challenge ಮಾಡಿ.
Kindly grant the liberty to.
I will grant. Yes, charge sheet. ಗೊತ್ತಾ ವಿಜಯಗೆ?
Much obliged.
7.
ಟ್ವೆಂಟಿ ನಾನು ನೋಟಿಸ್ ಮಾಡಿರೋದು, ಆಮೇಲೆ ಏನಾಗೇ ಇಲ್ಲ. KPID ಎಲ್ಲ ಇದೆ ಇದರಲ್ಲಿ.
IT Act, KPID.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿಲ್ವಾ ಇನ್ನು?
ಆಗಿದೆ.
ಚಾರ್ಜ್ ಶೀಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
Page 37, my lord.
No representation on behalf of the petitioner. List the matter after 8 weeks. Registry is directed not to list the matter prior to the expiry of 8 weeks. Pendency of this petition will not come in the way of further proceedings before the concerned court. Next.
8.
May be listed next week, my lord.
Why?
Charge sheet has been filed. my lord.
There's a counter file.
If charge sheet is filed, challenge it.
6 witnesses.
If charge sheet is filed,
6 witnesses are also examined.
charge frame ಆಗಿದೆಯಾ?
Charge frame.
Yes, sir. Anything else,
There
sir?
is a case and counter
Next week
case.
ಹಾಕೊಳ್ಳಿ.
Charge frame ಆಗಿದ್ರೆ I will not entertain, sir.
No, no, I'll file a memo for withdrawal next week. Any date.
No problem. List next week, yes. Entry ಮಾಡಿದ್ಯಾ?
I will.
ಏನಿಲ್ಲ. Pendency of this petition will not come in the way of further proceedings before the concerned court. Next.
Please.
9.
The accused number 2 and 3. Well, respondent number 2 today filed a halat in counter.
What's the matter, sir?
Here, entire allegation is
ಆಯ್ತು, ಈಗೇನ್ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಬರ್ತಾ ಇದೀರಾ 3 ವರ್ಷ ಆದ್ಮೇಲೆ? 3 ವರ್ಷ ಆದ್ಮೇಲೆ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಬರ್ತಾ ಇದೀರಾ?
ಯಾಕಂದ್ರೆ ಇದರಲ್ಲಿ
ಹಾಕ್ಲಿ objection.
other accused are not traced it. I am accused number 2 and 3. No role, anything in the.
Correct. What stopped you for 3 years? 23 matter.
ಅಲ್ಲಿ ಏನೋ
ನಾನೇ ಪೋಸ್ಟ್ ಮಾಡಿಸಿರೋದೆಲ್ಲ ತೆಗೆದು. ಏನ್ ಇಂಟ್ರೆಸ್ಟ್ ಇಲ್ಲ.
ಇಂಟ್ರೆಸ್ಟ್ ಇದೆ, ನಾನೇ ಟ್ರಯಲ್ ಕೊಟ್ಟು ನಾನೇ ಅಪೀಲ್ ಆಗ್ತದೆ. ಅಲ್ಲಿ ಅದರ್ accused are not traced it.
Whole case is based on Priyanka Srivastava is not complied. The charge sheet has been filed recently. Supreme Court my lord has
Yes.
considered that issue.
Cannot relate back once charge sheet is filed. Could you?
Charge sheet only challenged, my lord.
What is the ground?
Yes, my lord. There is no involvement of the accused at all. By seeing it, looking, entire allegation is against the accused number 1. I will take your lordship with the, it's a private complaint. Refer to the, without complying, Priyanka Srivastava. Apart from that, my lord, I will take your lordship with the charge sheet, my lord. Entire accused number 1 has taken the checks in our name. That's the allegation. We are not involved anywhere. No allegation, no nothing. We have invested with the complainant. And for investment, share with
File objection.
Okay.
Kindly.
The learned counsel, petitioner to serve set of papers upon. ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ?
Morning filed wakalat.
Learned counsel so and so undertakes to submits that is entered appearance for the second respondent complainant registry to print the name of so and so is appearing for the second respondent complainant. A learned counsel for the petitioner to serve entire set of papers upon the so and so counsel list the matter on Tuesday the next.
Apart from that, your honor, accused number 1 also filed criminal petition for 4557 of 2024. That case also stay is not granted.
Tag the petition along with so and so list.
Criminal petition number 4557 bar 2024.
List the matter on Tuesday. Yes.
Number 10.
Idyeno. For 10 years.
Charge sheet has been filed in special CC.
For the petitioner, my lords, I seek for a short accommodation. Senior has been engaged in this matter.
But don't repeat those submissions, it's still lingering in my mind. Yes.
Special CC 11 of 2023.
ಇಲ್ಲಿ ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಾರೆ ಅನಿಸುತ್ತಾರೆ? Atrocities Act.
If I'm correct, I think accused have been acquitted.
Acquitted. The petitioner is before this court seeking the following prayer. The learned counsel appearing for the learned additional SPP on information.
Charge sheet has been filed.
Information submits that charge sheet has been filed. Acquittal badwa? Charge sheet has been filed. In that light, liberty is reserved to the petitioner to challenge the charge sheet. All contentions that are raised before this court in the subject petition shall remain open in the petition that is to be filed if the petitioner so desires, challenging the charge sheet. Ordered accordingly. Yes, next.
7.
ಇದು ಅಷ್ಟೇ 23 ಇಂದ ಬಂದೇ ಇಲ್ಲ.
ಮ್ಯಾಟರ್ ಸೆಟ್ಲ್ ಆಗಿ ನಾನು ಮೆಮೋನು ಹಾಕಿದ್ದೀನಿ, ಲೀಸ್ಟ್ ಆಗಿಲ್ಲ ಅದಕ್ಕೆ.
ಆಯ್ತು. ಏನ್ ಮೆಮೊ ವಿಡ್ರಾಲ್ ಗ?
ವಿಡ್ರಾ ಅಲ್ಲ, ಮೆಮೊ ಸೆಟಲ್ಡ್ ಔಟ್ ಆಫ್ ಕೋರ್ಟ್ ಅಂತ ಮೆಮೊ.
learned counsel with the petitioner ಮೆಮೊ ಹಾಕಿದ್ದೀರಾ?
ಮೆಮೊ ಆಲ್ರೆಡಿ 24 ನಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ.
ಆಯ್ತು. ಇದೆಲ್ಲ ಹಾಕಿ ಮೂವ್ ಮಾಡ್ಬಿಡ್ಬೇಕು ತಕ್ಷಣ, ಸುಮ್ಮನೆ ಪೆಂಡೆನ್ಸಿ ತೋರಿಸ್ತಾ ಇರ್ತಾರೆ. ಎಸ್ ಇಲ್ಲಿದೆ ಮೇಡಮ್. In terms of the quote the memo, close it. Yes. Next.
12.
Charge sheet has been filed.
Charge sheet file ಮಾಡಿದ್ರೆ ಏನ್ ಚಾಲೆಂಜ್? ಕ್ರೈಮಾ?
Crime.
345 406 CC
8879 of 23.
The petitioner is before this court seeking the following prayer. The learned additional SPP on verification of the record submits that the charge sheet has been filed in the case at hand. At the learned counsel of the petitioner would now seek liberty to draw the petition and reserving liberty to challenge the charge sheet. The liberty so sought is granted. All contentions that are urged in the present petition are reserved to be urged in the petition that would be filed with the petitioner, comma, if so filed, challenging the charge sheet. Ordered accordingly.
13 charge sheet is filed.
For the petitioners in this matter, my lords,
Ah.
I seek for an adjournment senior.
Charge sheet file ಆಗಿದೆ.
CC 9350 of 23.
Challenge that. 3 years ಇಂದ ಸುಮ್ನೆ ಏನು ಮಾಡದೆ ಇದ್ರೆ ಹಿಂಗೆ ಆಗತ್ತೆ.
I request for a short accommodation, my lords. Senior is
Granted you a
traveling.
long adjournment. Yes.
Even your lordship refused, went to Supreme Court not
ಹೌದು,
granted it.
ಕೊಡಿ. ಸ್ವಲ್ಪ ಆರ್ಡರ್ ಕೋಟ್ ಮಾಡಿದ್ದೀನಿ. Protected the petitioner from arrest.
ಅಷ್ಟೇ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಕಂಟಿನ್ಯೂ ಅಂತಾನೆ ಆರ್ಡರ್ ಆಗಿದೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇಂದ. ಐ ವಿಲ್ ಪಾಸ್ ಆನ್ ದಿ ಆರ್ಡರ್ ಮೇಡಮ್.
ಮತ್ತೆ ಕ್ಲೋಸ್ ಆಗಿದೆ SLP.
ಇದು ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ.
Charge sheet ಆಗಿದೆ.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿ.
Challenge the charge sheet, sir.
No, my lords, there's one more writ petition pending along with this.
You already
both-
challenge the charge sheet.
Indeed, my lords, both are pending. So senior has
Indeed
to
ಅಂದ್ರೆ ಇದು
address this.
ಹೋಗುತ್ತೆ, ಅದರಲ್ಲಿ ಇಟ್ಕೊಳ್ಳಿ ಎಲ್ಲ ನಂಬರ್.
Oh, my lords, let the,
Number
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಲಿಲ್ಲ.
my lords, may the matter may be had day after tomorrow. Senior has to address his arguments. He has some submissions to be made, my lords. I have no directions for arguments in this matter from him, my lords. So hence I need a short accommodation in this matter.
ಏನ್ ಇದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಇಲ್ಲಲ್ಲ?
No interim order is
List after 4 weeks.
grateful, Swami.
Yes. Pendency of this petition will not come in the way of any further proceedings before the concerned court. Yes, next.
14.
Charge sheet has been filed, matters separated.
Become infractions, lordships. Petitioner's name are dropped from the
Dropped.
charge.
The petitioner is before this court seeking the following prayer. The learned counsel appearing for the petitioner submits that the police after investigation have filed a charge sheet, and in the charge sheet the name of the petitioner has been dropped. In that light, the petition is rendered infructuous. Petitioner is reserved liberty to knock at the doors of the appropriate fora in the event of need in future. Ordered accordingly. Next.
Bring first. 138 proceeding challenge. 138 proceeding challenged by.
138 3 ವರ್ಷದಿಂದ ಏನಾಗಿದೆ ಅಲ್ಲಿ?
NBW ಆಗಿದೆ. Petitioner ಗೆ NBW ಆಗಿದೆ. Not appeared.
No representation on behalf of the petitioner, 8 weeks, not to list. Pendency of this petition. Next.
15.
Lord, I appeal for the petitioner, my lord.
Hmm.
Lord, what is essentially a loan transaction between the complainant herein and accused number 1 to 5, I've been roped in as accused number 7. During the time of complaint, as well as filing of the FIR, I was not arraigned as an accused. But based on the statement of accused number 5, that I used to know him based on other transactions that we have done in the course of business, I've been arraigned as accused number 7. It's in page number 77, my lord. The statement given by accused number 7, accused number 5.
Right.
239 application filed by petitioner pending before trial court. And further investigation papers, my lord, is about to submit to the trial court in week's time.
Yes.
My lord, I have the copy of your lordship's order.
Correct. Dismissing.
That for accused number 13. In paragraph number 8, your lordship has observed, due to the overt role of accused number 13, where he had taken the car of the legislature assembly, government car. But here, the accused herein was not even present during the said transaction, or in no way is connected to any of the parties here.
This has become final?
Sorry, my lord?
This
Yes,
has
my
become
lord.
final?
There's no appeal from it.
Let's see. 1 additional SPP, 2 emergent notice. Yes.
17.
Yes.
3 ವರ್ಷ ಆದ್ಮೇಲೆ stay.
Petition, my lords. Matter has been settled out of court, my lords. Kindly filing memo for not pressing the petition, please.
In term, quote the memo and close it. Next.
For the petitioner, the petitioner is not available for the last 1 year.
Not available.
ಇಲ್ಲ ಎಷ್ಟು ಕಡೆ ಎಲ್ಲಿ ಫೋನ್ ಮಾಡಿದ್ರು ಸಿಗುದಿಲ್ಲ. ತಮ್ಮ ಮುಂದೆ
ಬಿಡಿ ಹಾಗಾದ್ರೆ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಲಾಯರ್ ರಿಕ್ವೆಸ್ಟ್ ಫಾರ್ ಎ 4 weeks adjournment so that we can report.
Normally NBW pending ಇದೆ.
It has come before your lordship earlier. NDB
2 weeks time is granted.
Yes.
Office objection overrule ಆಗಿ 2 ವರ್ಷ ಆಗಿದೆ. ಅಷ್ಟೇ.
ನಮ್ಗೆ ಕಾಂಟ್ಯಾಕ್ಟೇ ಮಾಡಿಲ್ಲ ಅವರು ಅದಕ್ಕೆ.
And
ಫೈನಲಿ
we'll close it ಬಿಡಿ. What is challenged?
charge sheet here before the Bantrwal court.
423, 420, 511.
Forged degree certificate is produced.
Anyway, list the matter after 8 weeks,
Yes.
same order. Pendency of this petition will not come here. Next.
19.
Petitioner, my lord.
Yes, sir.
Offense under section 397.
397?
Main case is acquitted, my lord. Split up,
Split charge.
Split up charge sheet, my lord. This petitioner is accused number 1, 2 and 3 are acquitted, my lord.
Ellide?
Page 44.
Internal page 19.
Page 19. Dacoity. The petitioner, will close it. Complainant, ಬೇರೆ ನೀವೇ ತಾನೆ?
Witness.
The petitioner is before this court, calling in question the continuation of proceedings against him in CC 7653 of 2016 for offences punishable under section 397 of the 397 matra na?
Also.
397 of the IPC. The learned counsel for the petitioner, the petitioner along with others gets embroiled in a crime, in crime number 542 of 2015 for the aforesaid offence. The concerned court after a detailed, the police after investigation file a charge sheet, and the concerned court after a detailed, file a charge sheet in CC 17204 of 2015. The petitioner at the relevant point in time was not available for trial. The accused 1 to 4 were tried in SC 490 of 2016, and the petitioner against the petitioner a separate split charge was directed to be framed on account of his absence during the trial. It transpires that the concerned court by its order dated judgment dated 25th July 2018 acquits accused 1 to 4 who were tried on the score that the prosecution has failed to prove the guilt beyond all reasonable doubt. Since the offence is the one punishable under section 397, which would be a collective act, the petitioner, if even permitted to be tried at this juncture, would not lead to anything but acquittal. In view of the said circumstance, permitting further proceedings against the petitioner would be waste of precious judicial time. In the light of that fact, though such accused who would escape trial should not be shown any mercy, owing to the fact of the aforesaid observation of judicial time being precious, I deem it appropriate to exercise jurisdiction under section 482/528 and obliterate the proceedings against the petitioner. The view of mine in this regard, allowed quashed. Next.
20.
138 matter, my lord. Total check amount was 35 lakhs, my lord.
ಈಗ ಏನಾಗಿದೆ 3 ವರ್ಷದಿಂದ ಸ್ಟೇ ಇಲ್ಲ, ಕ್ಲೋಸ್ ಆಗಿಲ್ಲ.
ಏನಾಗಿದೆ ಸೆಟ್ಲ್ಮೆಂಟ್ ಸಬ್ಜೆಕ್ಟ್ ಟು ಸರ್ಟನ್ ಕಂಡೀಷನ್ಸ್. ಈ ಟೈಮ್ ಕೂಡ ಪೇಮೆಂಟ್ ಮಾಡಬೇಕು ಅಂತ, ಆ ಟೈಮ್ ಒಳಗಡೆ ಪೇಮೆಂಟ್ ಮಾಡಲಿಲ್ಲ, ಆಟೋಮೆಟಿಕಲಿ ಒರಿಜಿನಲ್ ಅಮೌಂಟ್ ರಿಸ್ಟೋರ್ ಆಗಿದೆ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಪಾಸ್ಡ್ an order to pay additional 10 lakhs.
What has happened is there was a settlement, my lord. COVID ಆಯ್ತು, we have paid the complete amount, my lord. ಅವರು ಲೇಟ್ ಆದ್ಮೇಲೆ ಇನ್ನೊಂದು they have filed 2 memos, my lord. Kindly see in page 12, my lord, the first joint memo, my lord. 35 lakhs was reduced to 25 lakhs, my lord. My lord, it was 10 lakhs plus 15 lakhs had to be paid. I paid 10 lakhs, the remaining 15 lakhs I could not pay, my lord. There is one more memo, my lord, joint memo.
ಈಗ ಪೇ ಮಾಡಿದಾರೆ ಎಲ್ಲ
ಕಟ್ಟಿದೆ 10 ಲಕ್ಷ
25 ಲಕ್ಷ ಕೊಟ್ಟು ಇನ್ನು 10 ಲಕ್ಷ ಬರಬೇಕು.
ಕೊಟ್ಬಿಡಿ.
My lord, what has happened?
ಕೊಟ್ಬಿಟ್ರೆ ಇಲ್ಲೇ ಕ್ಲೋಸ್ ಮಾಡ್ಬೇಡ.
ಅಲ್ಲ, ಸೆಟಲ್ಮೆಂಟ್
ಆಗಿದ್ದು ಸೆಟಲ್ಮೆಂಟ್ ಬ್ರೀಚ್ ಆಗಿದ್ದಕ್ಕೆ ರಿವೈವ್ ಆಗಿದೆ ಎಲ್ಲ.
ಅಲ್ಲ, ಕೈಂಡ್ಲಿ ಸಿ.
ಅಲ್ಲ, ಈಗ ಸರ್ ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ ಎಷ್ಟಕ್ಕೆ ಸರ್?
ಅಲ್ಲ, ಒಂದು ನಿಮಿಷ,
ಅದು ಇರ್ಲಿ, ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದ್ದು ಎಷ್ಟಕ್ಕೆ?
ಅಲ್ಲ, ಆಯ್ತು, they have taken the money also. Once again they have filed one more memo.
ಈಗ ಟೋಟಲ್ ಕ್ಲೈಮ್ ಎಷ್ಟು ಸರ್?
35 ಲಕ್ಷ.
Settlement was for 25.
ಸೆಟಲ್ಮೆಂಟ್ ಎಷ್ಟಕ್ಕೆ?
25 ಲಕ್ಷ.
ಎಷ್ಟು ಕೊಟ್ರಿ?
25 ಕೊಟ್ಬಿಡಿ.
ಟೈಮಲ್ಲಿ ಕೊಡ್ಲಿಲ್ಲ.
ಅಲ್ಲ, ಟೈಮಲ್ಲಿ ಕೊಡ್ಲಿಲ್ಲ ಅಷ್ಟೇ. That's the only problem. ಏನೋ
Time
ಒಂಚೂರು
ಕೊಡ್ಲಿಲ್ಲ.
letting also my lord. ಅವ್ರ 5
ಅದು ಎಷ್ಟು 1 year ಡಿಲೇ ಅಷ್ಟೆಲ್ಲ ಆಟ ಆಡ್ಸ್ಕೊಟ್ಟಿದ್ದಾರೆ.
ಏನೋ ಒಂದು ಮಾಡಿ.
ಅಲ್ಲ ಏನಂದ್ರೆ ಹೇಳಿದ್ರೆ ಅವ್ರು
ಅಲ್ಲ,
ಏನಾದ್ರು ಒಂದು ಕೊಟ್ಟು ನಾನು
he's doing
ಏನಾದ್ರು
well.
ಒಂದು ಕನ್ಸೆಷನ್ ಮಾಡಿ
ಅಲ್ಲ,
ಅಂತ ಹೇಳ್ತೀನಿ.
he is doing well, we would not have said anything, my lord. 5 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಕ್ಕೆ 35 ಲಕ್ಷ ಚೆಕ್.
ಅದು
ಅಲ್ಲ, ಪರವಾಗಿಲ್ಲ. ಈಗ ಕೊಟ್ಟಿದಾರಲ್ಲ 25.
ಅಲ್ಲ ಅವ್ರು ಏನಾದ್ರು ನಾನು ಬೇಕಾದ್ರೆ ಈಗ ನನ್ನ ಕ್ಲೈಂಟ್ ಸಜೆಸ್ಟ್ ಮಾಡ್ತೀನಿ ಏನಾದ್ರು ಒಂದು ಸ್ವಲ್ಪ ಕಡಿಮೆ ಮಾಡಿ ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಈಗ 10 ಲಕ್ಷ,
Let him come up with a
10 ಲಕ್ಷ ಬರ್ಬೇಕು.
ಅಷ್ಟೇ.
5 ಲಕ್ಷ ಕೊಟ್ಬಿಟ್ಟು ಸೆಟ್ಲ್ ಮಾಡ್ಬಿಡಿ.
ಆಯ್ತು.
Take it and leave it.
ಹೇಳ್ತೀನಿ. ಹೇಳಿ.
I'll take it on Friday.
ಆಗ್ಬೋದು.
Take it and leave it, file a joint memo. Yes.
ಹೇಳಿ.
My lord, 17th or 18th.
ಯಾಕೆ?
ಪೇಮೆಂಟ್ ರೆಡಿ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ತೀವಿ.
ಅದು ಇಲ್ಲ.
ಅದು ಇಲ್ಲ, ಅವ್ರ ಹತ್ರ ಇಟ್ಟಿದ್ರೆ 17th.
ಆಯ್ತು. We'll take it on 17th. 17th, 18th ಇಲ್ಲ. Take it on 19th.
ಆಗ್ಬೋದು.
ಅಷ್ಟೇ. ಮಂಜುನಾಥ್,
ಆಯ್ತು ಆಯ್ತು.
ಕ್ಲೋಸ್ ಮಾಡಿ.
ಬೇರೆ ನಾಟ್ ಟು ಪ್ರೆಸಿಪಿಟೇಟ್ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದು.
ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. Entry matter shall continue to the next date. Nagendra avare, just finish it off. Yes.
21, my lords, so charges are framed.
My lords.
Charge framed when?
Charges framed, my lords, 7/12,
Settlement talks are going, my lordship.
Very good, sir. So charge framed.
7/12/2023 charges are framed.
ಯಾವತ್ತು?
7/12.
A week's time, my lordship.
ಒಂದು ನಿಮಿಷ sir.
7/12/2023, my lords, so charges are framed.
But petition is filed before that. No worries. Yes. What's the matter?
My lordship. Offences are under 406, 418 and read with 34 of the APC, my lordship. Settlement talks are going, my lordship.
420 na? The learned
418,
counsel for the petitioner submits that talks of settlement between the parties are afoot AFOOT and would seek 2 weeks' time to report such settlement, if any. The learned HCGP submits charges have already been framed and the matter is at the stage of evidence. In the normal circumstance, the subject petition ought to be dismissed for a trial to be continued. The indulgence is shown only on the statement that the petition that talks of settlement are on between the parties. Therefore, list this matter on 27th January in the fresh matters list. In the event the talks of settlement, in the event the settlement is not reported, the court would be left with no option but to dismiss the case for the trial to continue. Yes, ordered accordingly.
22.
ITP.
Yes, my lords. 3, 4, 5, 6, 7.
3, 4, 5, 6, 7, 8, 9, 10. No representation, same order. Next.
23.
For the respondent.
Yesterday.
Plus, this petition has become infructuous, my lord.
Why?
Plus, the stage at which this petition was filed at the stage of crime. Plus, that has become CC, their discharge is rejected. They have filed a revision before this honorable court. Hakidare.
Numbers kodiyalla.
But I'll just.
The petitioner is before the court seeking the following prayer. There is no representation on behalf of the petitioner. The learned counsel appearing for the respondent, Rahul Reddy, submits that a discharge application had been preferred by these petitioners before the concerned court. The discharge has been rejected. Against the rejection of the discharge, the petitioners have filed a criminal revision petition in criminal revision petition number so and so. In that light, the petitioner having availed the remedy that is available in law, the present petition in the form that it is presented would not become entertainable. In that light, leaving open to the petitioner to urge all the contentions before the concerned court in the appropriate proceedings, the petition stands disposed.
24.
My lords, FIR is challenged. Now the charge sheet is filed, my lords, CC number 1885 of 25. Special CC 1885.
An Atrocities Act, huh?
Buds Act, my lords.
Buds Act. The petition is preferred calling in question registration of a crime in crime number 97 of 2022. There is no representation on behalf of the petitioner. The learned counsel, learned HCGP on instruction and verification of the records would submit that the police, after investigation, have filed a charge sheet against these petitioners in CC number
1885/25.
1885 of 2025. In that light, the petition is disposed, reserving liberty to the petitioner to challenge the charge sheet, if any, if he so desires. The contentions that are urged in the subject petition are also reserved to be urged in the challenge to the charge sheet, if any, ordered accordingly. Next.
FIR challenge.
25.
25, my lords, FIR is challenged. My lords, now the investigation is completed.
NOC ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಬೇಕು. 2 weeks time.
ಏನಾಗಿದೆ?
Charge sheet is filed, my lords, CC number 18/700/2022. FIR is challenged.
Yes, same order. Ordered accordingly. Next.
26.
In this case, my lordship, the complaint filed by the respondent by invoking section 498A 3 and 4 on DP Act has ended with a conviction for the period of 6 months. Later, the state also preferred an appeal, same as said appeal also dismissed. Now revision is pending. Now meanwhile, the OS has been filed by the husband seeking decree of divorce. In the said petition, the compromise application came to filed annexure E, page number 82, my lord. For one side settlement of 13 lakhs.
ಆಯ್ತಾ? ಅದನ್ನು ಆಗಿದೆಯಾ?
ಅದನ್ನು ಆಗಿದೆ ಸರ್.
ಜಾಯಿಂಟ್ ಮೆಮೊ ಇದೆ ಇಲ್ಲಿ.
ಜಾಯಿಂಟ್ ಮೆಮೊ ಇದೆ. ಅಂಡ್
3 ವರ್ಷದಿಂದ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಅವ್ರು ಆಕೆ ಬರ್ತಾ ಇರಲಿಲ್ಲ, ಬರ್ತೀನಿ.
ಪೋಸ್ಟ್ ಮಾಡಿಲ್ಲ, ಪೋಸ್ಟ್.
ಅದು ಕನೆಕ್ಟ್ ಮೇಂಟೈನ್
ಕನ್ವಿಕ್ಷನ್ ಆದ್ಮೇಲೆ ವೆದರ್ ಇಟ್ ಕ್ಯಾನ್ ಬಿ ಸೆಟಲ್ಡ್ ಆರ್ ನಾಟ್ ಇಸ್ ದಿ ಇಶ್ಯೂ. ರಾಮ್ ಗೋಪಾಲ್ ಅಲ್ಲಿ ಕವರ್ಡ್. ಇಟ್ಸ್ ಆಲ್ ರೈಟ್. ಐ ಹ್ಯಾವ್ ಆಲ್ಸೋ ಡನ್. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ. ಎಸ್. ನೋಟಿಸ್ ಆಗಿಲ್ವಾ? ಎಲ್ಲ ಆಗಿದೆಯಾ?
ನೋಟಿಸ್ ಆಗಿದೆ.
ಆಗಿದೆ ಮಾಡಿ. The petitioner is before this court seeking the following prayer. The parties to the list, you were convicted, is it?
Yes, my lord.
The petitioner pursuant to certain proceedings gets convicted for the offence under section
498A 3, 4 and
498A 3 and 4 of the Dowry Prohibition Act, and after conviction has entered into a settlement with the complainant and have filed a joint memo reporting such settlement. The joint memo is appended to the petition. The issue now would be whether after conviction of the petitioner for the aforesaid offence can be closed on account of a settlement arrived at between the complainant and the petitioner. The issue is no longer res integra, as the apex court in Ram Gopal versus State of Madhya Pradesh in 2022, 14 SCC page 531 has held as follows. Paragraph held as follows. The apex court recognizes the fact that if the offence is not the one against the state, even notwithstanding the conviction, it can result in a settlement and closure of proceedings between the parties. In that light, further proceedings before the concerned court shall remain stayed till the appearance of the respondent. 1 HCGP, 2 emergent notice.
Sorry, my lord. Interim application now I have file ಮಾಡಿರಲಿಲ್ಲ.
ಹಾಕಿಲ್ವಾ? ಕೊಡಿ.
ಅವ್ರು ಬರ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು. ಆಲ್ ಆಫ್
ಆಯ್ತಾಯ್ತು. ಆರ್ಡರ್ ಅನ್ನ ಎ ಅಂತಾನೆ ಮಾಡಿ ಸೆಪರೇಟ್. The counsel for the petition files an application seeking stay of further proceedings. The same is taken on record, separate order sheet. ಆಮೇಲೆ ಆರ್ಡರ್ ಅನ್ನ ಎ. Yes, next.
For the petitioner, my lord.
ಈಗ ಯಾವ ಪ್ರೊಸೀಡಿಂಗ್ ಇದೆ ಪೆಂಡಿಂಗ್?
ಸಿಸಿ ಮೇಲೆ ವಾರೆಂಟ್ ಮಾಡಿದ್ದಾರೆ.
All right, yes.
Judgment.
This matter is
also pending, my lord. Appeal ಆಯ್ತು. Appeal
ಆಯ್ತಾಯ್ತು. Yes, we'll see. Yes, next.
My lord, in this matter, the matter has already been settled before the Loka Adalat last week. And it may be closed as not made.
Learned counsel for the petitioner submits that the matter has been settled before Lok Adalat. 138.
It's a 420 case. 420 case.
before the Lok Adalat. The submission is placed on record. In the light of the said submission, the petition is disposed as having become unnecessary today. Next.
28.
Applying for petition, my lord. The lead offences are 498A, 504, 506, and
Husband.
10 for dowry prohibition act.
Husband.
No, my lord. The petitioner is accused number 5. She is not a family member.
Why have you not moved these matters for 3 years, sir?
My lord, I had moved,
When
my
it
lord, it
can't
was listed,
remain-
it did not reach. My lord.
Yes, sir. What is all this? Why do you do all this? It would have been quashed by now.
I had moved, my lord, it was listed also, my lord, even before vacation.
For me, it is not
No, my lord,
listed at all.
before coordinate bench, it was listed, did not reach. And on one occasion, I could not appear due to ill health.
Intermodal ilva?
Intermodal ಇದೆ, my lord.
ಮತ್ತೆ? We'll close this then.
Please.
Who is the respondent?
Respondent number 2 is complainant.
Served?
Served, my lord. Wakalat has been filed.
ಯಾರು ಇದಾರಲ್ಲ ಕೊಟ್ರೇಶ್?
But they are not appearing, my lord.
A5 is the neighbor of A1, my lords.
ಗೊತ್ತಾಯ್ತು? Yeah. The petitioner is before this court seeking the following prayer. The petitioner is seeking the following prayer, brother. The petitioner is before this court calling in question. Petitioner, accused number 5, is before this court calling in question proceedings in crime number 28 of crime in CC 32092 of 2021, registered for offences punishable under section 498A, 504, 506, 323 and 34 of the IPC. Heard so and so. The petitioner is said to be the neighbor of a couple who get married on 13/2/2021, who get married on 17/11/2006, and their marriage appears to have gone to doldrums. The wife has registered, the second respondent has registered a crime, registers a complaint on 13/2/2021 for offences punishable under section 498A, 504, 506 and 34 of the IPC. The police, after investigation, file a charge sheet. The filing of the charge sheet and issuance of summons is what has driven the present petitioner, accused number 5, to this court in the subject petition. The learned counsel appearing for the petitioner submits that the petitioner has no role to play in the family of the accused number, family of other accused. The petitioner is the neighbor, and the only allegation against the petitioner is that she has instigated the husband to behave in a particular manner, and therefore therefore developing an axe to grind, the petitioner has been arraigned as an accused in the case at hand. The learned, per contra, the counsel appearing for the respondent would vehemently oppose the petition, contending that it is the petitioner who is the reason for all the behavior of the husband, and therefore the petitioner should also stand trial and come out clean in the same. The learned HCGP would toe the lines of the learned counsel appearing for the complainant in so contending. I have given my anxious consideration. The aforenarrated facts are a matter of record. The marriage between the accused number 1 and the complainant appears to have turned sour. The turning of the relationship sour leads the complainant to register a complaint on 13/2/2021 for the aforesaid offences. Since the entire issue is now triggered from the complaint, I deem it appropriate to notice the complaint. The complaint reads as follows, page 20 and 21. The police, after investigation, have filed a charge sheet. The summary of the charge sheet as obtaining in column number 7 reads as follows, page 22 and 23. The entire allegation against this petitioner, the name of this petitioner is nowhere found except contending that she has instigated the husband to torture the wife. Otherwise, the petitioner would not fit into the definition of family as is obtaining under the provision, i.e. 498A. In that light, a stranger cannot be drawn into the proceedings of offences between the husband, wife or the family members. The permitting further proceedings against this petitioner would become an abuse of the process of the law and result in miscarriage of justice. In that light, the petition stands allowed, the so-and-so stands quashed, qua the petitioner. It is made clear the observations made in the course of the order is only for the purpose of consideration of the case of the petitioner under 482 of the CRPC and would not become applicable to any other accused or influence the trial before the influence further proceedings before the concerned court, if any, against any other accused. Ordered accordingly. Next.
29.
29 and 29.1 are registered for offences under the Prevention of Atrocities Act.
Hmm.
My lords had passed an interim order on 22/5/2023 after hearing
Amel
the respondents, my lords. Amel Bantu, it had come last month, my lords. It was adjourned at my request. My lords,
Why did you
Mr.
take
Holla
adjournment?
has been engaged in this matter. Mr. Holla only appeared even at the time of
Who
the
appears
interim
as the
order.
respondent?
That's one, Arjun, yes.
Respondent. ಬರೋದೇ ಇಲ್ಲ ಅಂತ.
Matter may be had any day after the 8th, my lord. Mr.
Why?
Holla is not in station till
That's
then.
all right. 1 minute.
Essentially, my lords, there is no allegation against the petitioners herein. FIR is registered after a delay of 17
Interim order
months.
is 4 pages, sir. That is the final order. Yes. I've written everything in that.
Yes, my lords.
Objections ಹಾಕಿದಾರಲ್ಲ?
ಹಾಕಿದ್ದಾರೆ, my lords. Vacate stay no ಹಾಕಿದ್ದಾರೆ.
State has also
Both
filed
state
in court.
and private respondent have filed vacate stay.
ಮನು ಕುಲಕರ್ಣಿ appear ಆಗ್ತಾರ?
ಹೌದು, my lords. He's my senior.
ಅಲ್ಲ, objections here on the vacating stay.
Yes, my lords. Mr. Holla was engaged to appear for.
Where is Manu?
My lords, he's on his legs.
Pass over ಮಾಡಿ ಬರ್ಲಿ, ask him to come. There is a vacating stay application.
Yes, my lords.
Pass over.
Matter may be had subject to this court's convenience any date after the 8th, my lords, because client has
Ask
instructed.
Manu to come. Yes.
All right, my lords.
Pass over.
40.
APF for the petitioner, my lord.
Yes, sir.
Petitioner is the accused and former wife of the.
Former wife.
Former wife of the respondent. Two, my lord.
Hmm.
And there were multiple litigation between the petitioner and respondent number 2. And all those matters were settled before the National Lok Adalat, Shiroli.
Correct. I have already recorded that on 11/7/2023. 3 ವರ್ಷ ಆಗಿದೆ. ಆಮೇಲೆ ಏನಾಗಿದೆ?
ಆಮೇಲೆ ಬಂದೇ ಇಲ್ಲ, ಅದು stay ಇತ್ತು. That is the reason the matter has not come.
Who appears the respondent?
Now the respondent 2 is represented by an advocate.
Gopal Singh.
Gopal Singh. ಎಲ್ಲ ಸೆಟ್ಲ್ ಆಗೋಗಿದೆಯಾ?
ಎಲ್ಲ settle ಅಲ್ಲಿ he has given an undertaking, he is going to withdraw the
page
proceeding, page 49, para 5.
1 ನಿಮಿಷ.
May I read it?
1 minute.
Four proceeding were pending in Rajasthan and 2 one
49 ಅಲ್ಲಿ
49 ಅಲ್ಲಿ page 5. In case
para
of-
5.
Para 5. In case-
498, 12, 125, the appellant will get the case
Domestic
settled
violence,
through the petition
125 procedure,
and
the
section
application.
will be settled through so and so. And the applicant is not able to get ex parte. Money ಎಲ್ಲ pay ಮಾಡಿದ್ದೀರಾ?
Yes, ma'am.
All the terms of settlement is complied?
All comply ಆಗುವಂತ. ಅದು 498 ಅಲ್ಲಿ the accused has to appear there, then only that case will be closed.
ಇದು ಯಾವುದು? What is this case?
This is to 341, 324, 326.
ಇದ್ರ ಬಗ್ಗೆನೂ ಇದೆಯಾ ಇಲ್ಲಿ?
ಇದು ಹೌದು, ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಲಾಸ್ಟ್
ಕೊಡಿ.
ಬಟ್ ಸೆಕೆಂಡ್ ಲೈನ್ disposed ex parte or unilaterally, section 323 of IPC
Unilaterally section 323 or IPC
or any other case has been filed by the opponent in Bangalore, then the opponent will get them resolved through the consent or note not press. And even the settlement, the maintenance was also paid, and she has also got married for the second time.
The petitioner, sir.
One single petition.
The petitioner, who are you?
I'm the wife of respondent number 2. And accused CC number.
The petitioner accused in CC 24892 of 2021 is before the court calling in question the proceedings before the court registered for offences punishable under section 341, 324, 326, 506 of the IPC. The petitioner and the second respondent are husband and wife. Several disputes between them spring and the petitioner had registered several cases against the husband against the petitioner several cases. In the National Lok Adalat held in Family Court Sirohi, the petitioner and the respondent settled the dispute by drawing up certain terms of settlement. The settlement, insofar as the present petition is concerned, the terms of settlement also notices the pendency of the subject petition and any other case filed in the High Court at Bangalore or in the courts at Bangalore. The terms of settlement reads as follows. The Learned Counsel, page 48 to 50.
49.
48 to 50. Yes. The Learned Counsel for the petitioner submits that the second respondent, after the settlement is drawn, has already married someone else, and maintenance is also paid to you.
Yeah, paid.
And maintenance or any other condition that was stipulated in the settlement is also complied with by the husband. In the light of the settlement arrived at between the parties, which also recognizes the closure of the present proceedings, and the present proceedings emanating as a counterblast to what the petitioner had filed against the husband, not one but 3 cases. Further proceedings permitted to be continued in the case at hand would undoubtedly become an abuse of the process of the law. In that light, for the aforesaid reasons, the petition deserves to succeed. The petition allowed, quashed.
31.
But I paid for the petitioner.
Lord,
Second, my lords, FIR, my lords, on the same cause of action. Lords, the earlier FIR, my lords, is closed by filing a B report.
B report is accepted.
Report is accepted. My lords, then what happened, my lords? He files, my lords, PCR again. And thereafter, my lords, what happens is we get a stay, and my lords, the complainant goes and comes before this court, gets the B report set aside, my lords, and now is remitted back to the investigation. Lords, now, my lords, this, my lords, is the second FIR, my lords, that is on the same count.
First FIR ಯಾವ್ದು ಹೇಳಿ?
Lords, first FIR, my lords, is 140 of 2018.
This was again a PCR?
FIR, my lords.
Straight away, yes.
Straight away.
Offense?
Lords, offense 447, 504, 323, 354.
What happened to this B report, Aita?
B report accepted, my lords. This court set aside the B report and remanded back.
What happened later?
It is still pending, my lords. No investigation has also taken place.
Alli. This is second crime,
Second crime.
140 of, iದೇನು crime number?
Now, my lords, 75
ಇದು
of
PCR
20
ಇದು?
PCR agi refer agi
75 of 22.
75 of 22.
Yes, we'll close this.
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ
ಎಷ್ಟು crime ಬೇಕು?
ಅಲ್ಲ ಬಿ ರಿಪೋರ್ಟ್ ಕೋವಿಡ್ ಬರೋದಕ್ಕೆ ಮೊದಲು ಇದು ಮಾಡಿ ನನಗೆ ಆಪರ್ಚುನಿಟಿ ಕೊಟ್ಟಿಲ್ಲ.
ಆಯ್ತು, ಈಗ ವಾಪಸ್ ಹೋಗಿದ್ಯಲ್ಲ? ವಾಪಸ್ ಹೋಗಿದ್ಯಲ್ಲ ಈಗ?
ವಾಪಸ್ ಹೋಗಿದೆ, ಇಲ್ಲಿ ಸೆಟಸೈಡ್ ಆಗಿ ಹೋಗಿದೆ, ಆದ್ರೆ ಸ್ಟೇಟಸ್ ಏನಾಗಿದೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ.
ಅದೇನಾರು ಇರ್ಲಿ, ಎರಡೆರಡು ಕ್ರೈಮ್ ಮಾಡಕ್ಕಾಗತ್ತಾ?
ಅಲ್ಲ ಅದಕ್ಕೆ ಮೊದಲು ಇದು PCR ಹಾಕಿದ್ದು.
ಯಾವ್ದಕ್ಕಿಂತ ಮೊದಲು?
ಸೆಟಸೈಡ್ ಆಗುದೇ ಮೊದಲು ಹಾಕಿದಂತ PCR.
ಸೆಟಸೈಡ್ ಆಗೋಕ್ಕಿಂತ ಮೊದಲು ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕ್ತು ಅಂತ ಇನ್ನೊಂದು ಕ್ರೈಮ್ ಹಾಕಕ್ಕಾಗತ್ತೆ?
ಅಲ್ಲ ಅದೇ ಮ್ಯಾಟರ್ ಬಗ್ಗೆ
ಮತ್ತೆ
ಅಲ್ಲಿ ಏನು
ಏನಾರು ಆಗಿರ್ಲಿ, this crime will not sustain.
ಅಲ್ಲ ಯಾಕೆ
You pursue that.
ಅಲ್ಲ ರೆಸ್ ಜುಡಿಕೇಟರ್ ಬರಲ್ಲ ಇದರಲ್ಲಿ, ಯಾಕೆಂದ್ರೆ ನೋಟ್
ರೆಸ್ ಜುಡಿಕೇಟರ್ ಮೇಲೆ ಅಲ್ಲ ಸರ್. You can't have 2 crimes on the same cause of action. What res judicata you are talking of? I am not talking of res judicata. It is multiple crimes.
ಅಲ್ಲ ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಈಗ ಸೆಕೆಂಡ್ ಅಲ್ಲಿ ಆಗೋದು ಏನು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗಿದೆ ಒಂದರಲ್ಲಿ ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ನಾನು ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಕೋರ್ಟಿಗೆ ಸಬ್ಮಿಟ್ ಮಾಡ್ತೇನೆ. ಆ ಸ್ಟೇಟಸ್ ಏನಾಗಿದೆ?
What is the status there?
Nothing has happened. No, my lords, accused is also not called for investigation, my lords. Pending, my lords, as like that only from 2023.
ಅದಕ್ಕೆ ನಾನು ಅಲ್ಲಿ ಯಾವ ಸ್ಟೇಟಸ್ ಏನು ಅಂತ ನೋಡಿ ಕೋರ್ಟ್ ಗಮನಕ್ಕೆ ತರ್ತೇನೆ.
ಎರಡೆರಡು ಆಗಲ್ಲ, ಇದಂತೂ ಕ್ವಾಶ್ ಮಾಡ್ತೀನಿ.
ಆ ಕೇಸ್ ಏನಾಗಿದೆ ನೋಡಿ ಇದನ್ನ ಮತ್ತೆ ನಾನು
list on 20 list next Tuesday in the same stage. The Learned Counsel for the petitioner submits, this court had on 5/6/2023 passed the following order. While granting the interim order, it is noticed that the B report was filed and the B report was accepted without accepted. Learned Counsel Mohan Chandra, appearing for the respondent, submits B report was accepted without hearing the petition, hearing the complainant, and therefore the matter it was challenged before this court. This court has remitted the matter back to the hands of the concerned court after setting aside the order accepting the B report, and the matter is at that stage. During the pendency of the acceptance of the B report, sprang the present crime in crime number 75.
after accepting of B report.
After accepting of B report, the present crime in crime number 75 of 2022 had sprung. Therefore, this court had passed the aforequoted interim order. The learned counsel Mohan Chandra submits that he would secure instructions with regard to the stage of the proceedings in crime number 140 of 2018. Whatever be the stage of the proceedings, if the proceedings are pending, it is open for the petitioner to pursue all or contend everything in that crime. Only to secure instructions, the matter is being adjourned to the next Tuesday. In the event no instructions would come, this court would be left with no option but to apply the law and allow the petition. Yes.
42.
Petitioner, my lord. The private complaint has been filed by the respondent, my lord, seeking only recovery of the money, my lord, 2,55,000. That, my lord, annexure F, my lord. I have already paid. Interim order there, my lord. Page number 50.
Lord, I am for the respondent, my lord.
Yes.
52, my lord. Annexure F, I already pay the amount, my lord, on dated 4/5/2052.
1 minute, madam. Where is the complaint?
Complaint, my lord. Annexure B, page number 37, my lord. 43 is the prayer, my lord.
Which petition are you holding?
Criminal petition 3896 of 2023.
Other interim order illa.
Connected matter.
Connected allide. What's the matter? Tell me.
My lord, page number 43 is the prayer, my lord. Prayer is, my lord, the recovery of the balance sale price of onions, my lord, 2,55,000.
Page
43, my lord. Private complaint.
Then KPM Act.
Lord, APMC Act, my lord.
APMC Act.
APMC matter, my lord. Since is delayed payment of
And also recover balance sale price. Ella kottagide ಈಗ.
Please, my lord. That is there in page number 52, my lord. Annexure F.
52.
Please, my lord. In that second para, my lord.
1,75,000 total. ಎಲ್ಲ ದುಡ್ಡು ಬಂದಿದೆಯಲ್ಲ?
Lord, the complaint is filed in time. Lord, after filing of the complaint, the petitioner has made the payment. Lord, the section 117B is the penal provision for the complaint. Lord, and subclass 2 of 117B.
ಯಾವುದು APMC Act?
Please, APMC Act, my lord.
ಕೊಡಿ ಮೇಡಮ್. ಕೊಡಿ ಲೀಸ್ ಕೊಡಿ.
Hmm. 117B, my lord.
117A na?
B, my lord.
B.
Subclass 2. Any person prosecuted under subsection 1 shall not be absolved from his obligation of payment of price to the seller or any other amount due from him under the act and bylaws. So just because now he has paid the payment to the farmers, the delayed payment the prosecution launch ಮಾಡಿದೀವಿ, that cannot be thrown out.
Anyway, you have contravention of section. Farmers ಕೊಡದೇ ಇದ್ರೆ ಅಂತ ಇದೆಯಾ ಅಲ್ಲಿ?
Please.
Any person carrying on business in the market, private spot, exchange, farmers
fails to pay the price to the seller.
Price. Yes, the provision itself is there, madam.
My lord, that is, my lord.
Otherwise, recovery of money crime cannot be registered, correct? But there is a specific provision here.
There is a provision, my lord, 84, my lord. Section 84, my lord. Provision of settlement of dispute also there, my lord. That opportunity is not given to me, my lord. Section 84, my lord.
Section 8 for the purpose of settling disputes, buyers, sellers, their agents, including payment of any agriculture. Yes, sir.
Lord, that is for arbitration.
Before 84, how did you register the crime, sir?
Lord, arbitration is between.
I cleared this, my lord.
One minute, madam.
My lord, may kindly see page section 75 for a moment, my lord. Subject to any deductions, if any, authorized deductions according to this act or the rules or bylaws or under any other law funded.
He shall be liable to make In case the buyer does not make the payment, he shall
Payment
be
under
liable to
subsection
make
1, he shall be liable to make additional payment at the rate of 1% per
within
day.
5 days.
Within 5 days, my lord. In case he doesn't do so, then
Yes.
6th day his license also will be cancelled.
You cancel
So,
ಮಾಡಿದಿರಲ್ಲ ಅದು.
license is cancelled. So far
Cancelled
as
and there is cost also.
and so far as recovery of the payment and for the penalty for not paying under section 75, the 117B is the penal provision, my lord.
Fails to pay the price seller without reasonable cause. Without reasonable cause. Cause would have been shown if 84 was invoked.
But they had filed in respect of cancellation of license. They had filed before the director also that appeal came to be dismissed. And
Against cancellation of license, they may have filed. But to invoke the penal provision, there is some precursor here.
Cancel of license, my lord, and forfeited shop. I have filed before the director.
Correct.
Director
Separate cause of
dismissed.
action.
Then I have filed before this honorable court has been allowed, my lord. That
Correct.
judgment have passed, my lord.
Where is the judgment? What do you want? Anything else, sir? Liberty to file application strictly. When application adu?
12 class 2, rule 12 class 2, my lord. Since my 55 months has been completed. Before this case is over, I have filed the petition before 2021, my lord. My license period has been completed. Hence, they have made it leave conversion of leave and license to lease consent.
Yes, sir.
But when there is a specific provision under penal provision under 117.
Absolutely, sir. It's a penal provision, but it should be preceded by. No.
Millard, my humble submission is section says 84, Millard. If they raise a dispute between traders for having supplied the goods and the buyer does not pay back the goods, then they have an option to come into the market committee to go before the arbitration, Millard. Here, Millard, a poor farmer is coming before the market committee and asking for recovery of the amount from the petitioners, and they have not paid the price. Payment is made in 2020. We have filed the case in 2019, and the default, Millard, is from 2018.
No, why you did not invoke this 75 or 84 rather?
Millard, when the farmer, Millard, seeks for 84, Millard, we would invoke. Farmer is asking for us to recover the amount itself. When the Millard, this is a dispute between two parties, and Millard, there is a clause in 84 also that they can go before the civil court also. If they do not want to refer it to the arbitration. But here, Millard, is a clear provision, but that he has not paid the price, and he has clearly violated section 75. 117B is the penal provision, Millard.
No, that time aware, sir. You need not repeat. I'm only asking before invoking this penal provision.
This is not compulsory, Millard. 84 is not compulsory. It is only between the parties, Millard. If they want, there will be arbitrators, panel of arbitrators before every market committee. And if the party want to take benefit of that arbitrators, they would seek the dispute to be referred to the arbitrators under section 84. Or if they want to go to the civil court, they will seek permission.
There is one clause here, without any reasonable cause, in 117B. That makes all the difference.
Please.
They are entitled to show reasonable cause for making or not making the payment. When when that reasonable cause can come about if there is settlement of dispute initiated under 84.
Millard,
penal provision, you can't straight away do it without, if reasonable cause irrilla andidre.
Millard, after the farmers complained to us, we issued notices to the petitioner. Notice to the petitioner to come and pay it up. ಇಲ್ಲ ನೋಟಿಸ್ ಕೊಟ್ಟಾದ್ಮೇಲೆ ಕೊಡ್ಲಿಲ್ಲ. ಅದಾದ್ಮೇಲೆ 2019 ನಲ್ಲಿ 2019 ನಲ್ಲಿ the complaint is filed. Thereafter 2020 they have made the payment. After the complaint is filed, summons is served. ಅದೆಲ್ಲ ಆದ್ಮೇಲೆ ಪೇಮೆಂಟ್ ಮಾಡಿರೋದು.
Yes.
Notice also
Voluntarily,
issued
they
by
have not made the payment in view of the notice issued by the
Farmers
APMC.
kata kodtira. You are a trader?
I'm a commission
Then?
agent trader. Dasanpura market as is
Why do you trouble the farmers by not
trouble
making
ಮಾಡೇ
them?
ಇಲ್ಲ because ನನ್ನ ಅಮೌಂಟ್ APMC ನಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಇರುತ್ತೆ, ಸೆಕ್ರೆಟರಿ ಹತ್ರ ಡೆಪಾಸಿಟ್ ಇರುತ್ತೆ.
APMC has to make the payment.
ಅಲ್ಲ ನಾವು ಪೇಮೆಂಟ್ ಮೇಕ್ ಮಾಡಬೇಕು.
ಮತ್ತೆ?
ಇನ್ ಕೇಸ್ ಇಫ್ ಐ ಆಮ್ ಎ ಡಿಫಾಲ್ಟರ್ they have my deposit, they can make it. ಅದು ದಾಸನ್ಪುರ ಮಾರ್ಕೆಟ್ ಯಾರ್ಡ್ ಬಂದ್ಬಿಟ್ಟು ನ್ಯೂಲಿ ಫಾರ್ಮ್ಡ್ ಮಾರ್ಕೆಟ್. ನಾನು ಯಶವಂತಪುರದಿಂದ ನನಗೆ ಅಲ್ಲಿ ಶಿಫ್ಟ್ ಮಾಡಿದ್ರು ದಾಸನ್ಪುರಕ್ಕೆ. ಮೀನ್ ವೈಲ್ ಕೋವಿಡ್ ಪೀರಿಯಡ್. ಸೊ ನನಗೆ that is the reasonable cause I have made it.
Farmers you can't trouble taking shelter under COVID.
ಕೇಳ್ದೆ ನಂಗೆ ಸ್ವಲ್ಪ ಕಾಲಾವಕಾಶ ಕೊಡಿ, ನಾನು ಪೇ ಮಾಡ್ತೀನಿ ಅಂತ ಕೇಳ್ದೆ. Meanwhile they have initiated this and I have made a payment also.
2018 is the default period, my lord. There was no COVID at that time.
ಅಲ್ಲ 19 ನ್ಯೂ ಮಾರ್ಕೆಟ್ ಯಾರ್ಡ್
19 lo COVID ಇರಲಿಲ್ಲ, 20 lo ಬಂದಿದೆ.
19 ಅಲ್ಲಿ ನನಗೆ ನ್ಯೂ
ಅದು COVID-19 ಬಟ್ ಶುರು ಆಗಿ 20.
ಅಲ್ಲ ನನಗೆ ಪೇಮೆಂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅದು ನ್ಯೂ ಮಾರ್ಕೆಟ್ ಯಾರ್ಡ್ ನನಗೆ ಸ್ಟಾಕೇ ಬರ್ತಿರ್ಲಿಲ್ಲ, ಬಿಸ್ನೆಸ್ ಡಲ್ ಇತ್ತು.
All that is not the reason for penal provision, but a reasonable cause matra they should have taken note of that.
ನನ್ನ ಲೈಸೆನ್ಸ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ
Kindly see page 39 of the petition, para 15 of my complaint. In para 13, my lord.
This was a ramification, that's why I am hearing otherwise.
Page 39 of the writ petition, my lord. 39 of the writ petition, para 13 of my complaint, my lord. 13, 14 are the farmers who had given the complaint on 24/11/2018, and in the para 15, my lord, submitted the complaint and issued a notice dated 11/12/2018 to the accused in respect of the complaint filed by so and so, and called upon it to pay the sale price. It is submitted on 17/12. Another farmer gave a complaint. And para 17, my lord, submitted the complaint, issued a notice on 18/1/2019 to the accused in respect to the complaint by so and so, and called upon it to make the payment. Again, my lord, para 18, 4/1/2019, other farmer gave a complaint. So para 20, I have given a notice to him again on 5/2/2019. In spite of that, they do not make a payment, my lord. After the CC is launched, summons is received, then they come and make the payment, my lord. Just making the payment would not absolve their guilt.
Yeah, one nimsham.
117B, my lord, where I have failed. Since they have issued a notice, I have replied it, I have made a payment.
Where ಯಾವಾಗ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದು ಯಾವಾಗ ಮೇಡಮ್?
2019, my lord, that I have
8/3/2019 is the notice.
Please, my lord.
ಅಲ್ಲ, ಎಲ್ಲಿದೆ ನೋಟಿಸ್? ಎಲ್ಲಿದೆ
Notice ಇದ್ರಲ್ಲಿ ಹಾಕಿಲ್ಲ.
No, I am examining only because if this is permitted, then every farmer will be troubled. Otherwise, reasonable cause, yes.
My lord, that is Yeshwanthpura market yard. I am a commission agent.
Aaytu madam, adirli. Now that's not the issue. Now where is the notice issued to you first?
2019 they have issued a notice.
Where is that? What is your reply to that? What is your reply to that? Notice alli payment madilla anta notice ಮಾಡ್ಕೊಟ್ಟಿದಾರಾ?
Please, my lord, I replied that, my lord, I'll give me some times, then I'll make a payment. Since I have issued the check has been bounced.
Check dishonor ಆಗಿದೆ.
Then I'll make a payment. I have requested the secretary.
ಆಮೇಲೆ ಯಾವಾಗ ಪೇಮೆಂಟ್ ಮಾಡಿದ್ರಿ?
Proceedings has been done.
ಅಷ್ಟಲ್ಲಿ proceedings initiate ಮಾಡಿದ್ರು.
Proceedings initiate ಮಾಡಿದ್ರು. Meanwhile, I have made a payment, my lord. Then I have come before this honorable court and writ petition, my lord. They have cancelled my license.
ಪೇಮೆಂಟ್ ಬಂದಿದೆಯಲ್ಲ ಬಿಡಿ. Yes. Respondent.
Please, my lord.
Illa I'll have to answer reasonable cause. I will answer.
Lord, the complaint is
prosecution can be initiated only if they don't show reasonable cause in not making the payment.
And also farmers.
What is reasonable cause? Will be subject matter of 84 proceedings.
My lord, every complaint.
That is why ಈಗ ದುಡ್ಡು ಬಂದಿದೆ ಅಂತ ಸುಮ್ಮನೆ ಕ್ವಾಶ್ ಮಾಡಿದ್ರೆ ಫೈನ್, ಇಲ್ಲಾಂದ್ರೆ ಐ ವಿಲ್ ಆನ್ಸರ್ ಆಲ್ ದಟ್. If you still insist that yes, there is delayed payment and he should face prosecution, andre we will do it. We will answer.
My lord, they would take advantage, my lord, keep it for years together, then make the payment, my lord, and they would seek.
That is why farmers should not be troubled anta ashte. Yes, madam.
Farmers has been replied, my lord.
No. Bitre these traders will not pay farmers at all. Unless this penal provision which is in favor of the farmer will not be tinkered. ಈ ಕೇಸಲ್ಲಿ ಏನು ತೊಂದರೆ ಇಲ್ಲ, ವಿಲ್ ಕಾಸ್ಟ್ ದಿಸ್, ಬಟ್ ದಟ್ ಡಸ್ ನಾಟ್ ಮೀನ್ ದಟ್ ಆನ್ಸರ್ ದಟ್. ದುಡ್ಡೇ ಪೇ ಮಾಡಲ್ಲ ಆಮೇಲೆ ನೀವು.
For that I have suffered, my lord, 4 years, my license has been cancelled. Now they have revoked.
Let me see.
That to filing the contempt petition,
We'll
my license has been
We'll
revoked.
answer it on next Tuesday, same stage, we'll dictate on that.
Much of this.
Is book ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಡಿ, book ತರಿಸಿ ಮೇಡಮ್. Book. Yes. Yes, next. Entry mortar ಇದೆಯಾ?
Entry mortar ಇದೆ madam.
Entry mortar subsisting will continue to the next date of hearing.
For the petitioner, my lord. 498, 307 and 342, my lord. Petitioner is the mother-in-law's younger sister, my lord.
Mother-in-law's younger sister.
Younger sister. Except for stating her name that she has given him ideas to harass her, there's nothing else.
You have a lot of ideas, is it?
Hello?
You have a lot of ideas to harass.
Well, in fact, she is not staying together. All the incident has occurred in Bangalore. The petitioner is a resident of Hyderabad, my lord. They had
The
no
petitioner is before this court calling in question proceedings in CC Agilva.
ಇಲ್ಲ, it was stayed at crime.
Calling in question the registration of a crime in crime number 337 of 2022 registered for offence punishable under section 498A, 342, 307 and 34 of the IPC. The petitioner is accused number 4, heard so and so. The second respondent is the complainant. The first petitioner son.
First petitioner is the husband, my lord. No, my lord. She is the
Yes, petitioners idare illi.
second. She's
ಒಬ್ರೇ ತಾನೇ ಇಲ್ಲಿ?
ಒಬ್ರೇ, my lord.
The complainant and the accused number 1 get married on 12/11/2001. It transpires that the relationship between the accused number 1 and the complainant flounders. On floundering of the said relationship, the parties are before the family court in MC 318 of 2019. The wife then registers several proceedings including a proceeding under section 125 of the CRPC seeking maintenance. The issue in the list does not pertain to those proceedings between the husband and the wife. The second respondent complainant registers a complaint on 17/11/2022, which becomes a crime in crime number 337 of 2022 for the aforesaid offences. The petitioner is arraigned as accused number 4. The arraigning of the petitioner as accused number 4 is what has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner submits that the petitioner is no way concerned with the happenings in the family between accused number 1 to 3 and the complainant. The petitioner is the younger sister of
Accused number 2, my lord.
Younger sister of accused number 2, that is the mother-in-law of the complainant, and does not even reside with the couple. The only allegation against this petitioner in the complaint is that she has orchestrated the behavior of the husband or the members of the family to treat the complainant badly. Except barring this, the learned counsel submits that there is no other allegation that would drive home the offences. The complainant, though served long ago, has remained unrepresented even today. Therefore, the learned HCGP is heard. The learned HCGP on perusal at the complaint or the material of investigation as was done till the date on which the stay was granted would submit that the investigation must be permitted to be continued against this petitioner, as well as there is some material to show the involvement of the petitioner in the affairs of the family of the complainant. Therefore, would seek dismissal of the petition. I have given my source. Therefore, narrated facts are a matter of record or averment in the petition itself. The entire issue gets triggered by the complaint so registered by the second respondent complainant. Therefore, I deem it appropriate to notice the complaint. The complaint reads as follows. Shall I the typed copy complaint?
31 and 32, man. 31 to 33, man.
31.
Please, man.
Typed copy.
Please, man.
31, 33 page ಇಲ್ಲ
31 to 30.
ಇದು ಕೊಡಿ ಮೇಡಮ್. ಕೊಡಿ ನಿಮ್ದು ಕೊಡಿ. The complaint reads as follows. Give a copy of this. A perusal at the complaint would indicate all offences against the husband, mother-in-law or father-in-law. The threatening to kill the wife by the husband or the or other members of the family is against them. Insofar as the present petitioner is concerned, what is found in the complaint is as follows. It is the allegation that the petitioner, for years since the start of marriage, has been tutoring the husband and giving ideas as to how to harass the complainant. Barring this, there is no other allegation against the petitioner, while the allegations galore against the accused number 1, 2, or 3 as the case would be. Therefore, it would be for them to answer the allegations. The petitioner, finding no allegation against the petitioner that would touch upon the ingredients of the offence under section 498A or even 307 of the IPC, permitting further proceedings, would run foul of plethora of judgments rendered by the apex court on the issue. In that light, the plethora of judgments rendered by the apex court on the issue, paragraphs are ಹೇಳ್ತಾರೆ. In that light, the petition deserves to succeed with the proceedings, with the investigation in crime number 337 of 2022, where the petitioner to be quashed. For the aforesaid reasons, the following order. Allowed, quashed, where the petitioner, accused number 4, it is made clear than parag. Yes, hello, next.
34.
Petitioners are accused number 4 and 5 Manaship, 498A Manaship, 323 Manaship. The petitioner number 1 and 2 relatives of the accused number 1.
Vacating stack idare.
Manaship.
Accused number yaru?
Accused number 4 and 5 Manaship. The relatives of the accused number 1 Manaship. The allegation against Manaship. ನನ್ನ ಗಂಡನ ಸಂಬಂಧಿಕರಾದ ನಾಗರಾಜು ಮತ್ತು ಆತನ ಹೆಂಡತಿ ವಿಮಲಾ ಎಂಬುವರು ನನ್ನ ಗಂಡನ ಮತ್ತು ಅವರ ಮನೆಯವರ ಜೊತೆ ಸೇರಿಕೊಂಡು ಅವರಿಗೆ ಕುಮ್ಮಕ್ಕು ನೀಡಿದ್ದು ಮನುಷ್ಯ ಕಂಪ್ಲೇಂಟ್ ಮನುಷ್ಯ.
The application is filed seeking vacation of the interim order. The interim order on 23/5/2023, this court had passed the following order. An application is preferred seeking vacation of the interim order. There is no representation on behalf of the respondent who has filed an application. Yaar hakiradu? State
Manaship.
State hakiradu. Yen nimge interest 498 ಅಲ್ಲಿ
Compromise settle the parties between the
Settlement ಆಗಿದೆಯಾ?
settlement family
ಎಲ್ಲಿದೆ?
court ಅಲ್ಲಿ MC 2/2024.
Where is that?
Manish copy not at receive Manish
MC?
28/11/2025. MC 2/2024. Senior Division JMFC Vaskote Manish.
2/2022.
Manish compromised on 28/11/2025. Senior Division JMFC Vaskote Manish.
We'll close it. The petitioner is before this court calling in question registration of a crime in crime number 92 of 2023, registered for offence punishable under section 498A, 323, 504, 506. The petitioners are accused 4 and 5, distant relatives of accused number 1, 2, and 3. The second respondent is the complainant. The complainant and accused number 1 get married. On 11/12/2022. Soon it transpires that soon after marriage, the relationship between the accused number 1 and the complainant flounders. On floundering of the relationship, the complainant, the second respondent complainant registers a crime in crime number 92 of 20, which becomes a crime in crime number 92 of 2023 for the aforequoted offences. The petitioners are also dragged into the web of crime. The dragging of the petitioners into the web of crime is what has driven these petitioners to this court in the subject petition. This court had protected the interests of these petitioners by passing the following order. The interim order is in subsistence even as on date. The learned counsel appearing for the petitioner submits that the petitioners are distant relatives and did not reside with the couple at any point in time, and therefore none of the offences can be laid again. None of the ingredients of the offences are even present in the case at hand, qua the petitioners. The learned counsel would further contend that the parties to the list have settled the dispute in MC2 of 2022 by drawing up terms of settlement on 28/11/2025, which also recognizes the closure of these proceedings. The learned counsel appearing for the respondent would not dispute the position of settlement between the parties. Be that as it may, settlement or otherwise, the offences against these petitioners as found in the complaint is as follows. Elidada?
Page number 21. Page number 21, fifth line, Manush. ನನ್ನ ಗಂಡನ ಸಂಬಂಧಿಗಳಾದ ನಾಗರಾಜು ಎಂಬುವರು ಮತ್ತು ಆತನ ಹೆಂಡತಿ
is as follows, page 21 in the. Barring this allegation against these petitioners, there is nothing that would drive, there is nothing that is alleged. If this be the allegation against these petitioners, it would only be an omnibus allegation of instigation to the family of the husband or family of the husband to act in a particular manner against the wife. If the allegation be that the added circumstance is that the parties to the list have settled the dispute amongst themselves in MC2 of 2022 on 28/11/2025. With all these being and also finding no allegation that would touch upon the ingredients of the offences under 498A, 323, 504 or 506 of the IPC as is alleged, permitting further proceedings would run foul of plethora of judgments rendered by the apex court on the issue. Quoting them would only bulk the subject judgment, as it is now settled principle of law. The permitting further proceedings would become an abuse of the process of the law and result in miscarriage of justice, allowed quashed, qua the petitioners.
MC2 bar 2024.
2 bar 2024. Yes. Next.
35.
For the petitioner accused persons, my lord.
427, 447.
Yes, my lord. My lord, the issue here is there was one property bearing serial number 25/3 in Vidrahalli village and spanning across 2 acres, 40 guntas. The father of the petitioners herein had sold 1 acre, 36 guntas to one person in 2004 and 5. And the remaining portion after the death of the father of the petitioners was sold off to a third party buyer. Legally, all the mutation records and other relevant records are in the name of the petitioners herein at the time of the sale. And therein, the buyer of that said portion.
Who is the complainant?
Sorry,
who is the complainant?
The complainant is a person that says that we have gone to their residence and threatened them. They had filed an application for police protection. They're saying that we have trespassed on their property. They're no way related to this transaction in any manner whatsoever.
Civil suit hakidara?
Civil suit hakidara.
Ilva.
Akili. It is between the third party and my party herein.
Yes, madam.
The complainant is no way related.
Your Lordship, the complainant, I am for the respondent number 2. Respondent number 2 is the owner of the property into which the petitioners have trespassed. The petitioners may own a property in the same survey number. They have falsely portrayed it to be
Who has filed civil suit?
Civil suit has not been filed.
Akelva.
The civil suit is filed by the purchaser that I sold the second portion of the property to. The complainant here is unrelated to that transaction. That is was food for specific performance. The complainant here is no way related to these transactions.
How do you demonstrate that you are the owner of the property?
Your Lordship, there is a court order in our favor,
Page.
injunction. It is page number.
You filed your objections?
Yes, Your Lordship. At page number 7 of the objections, we have produced a court order.
One moment.
it clearly mentions, and this is against the, Your Lordship, as mentioned, the said Obalappa, from whom, who is the ancestor of the petitioners, he had sold the property to one K. N. Nagendra Reddy, who is the vendor of,
The
who is
complainant.
my vendor.
Yes.
I had filed a suit for injunction and declaration against him, in which there is a order in my favor.
OS 11, no, yes. So you are in possession of the property?
Yes, I am in possession. The petitioners have subsequently come and harassed and trespassed into our property, due to which I filed a complaint dated 4/10/2021. After which FIR has been registered and charge sheet has also been filed. Subsequent to this, Your Lordship, they have once more come and harassed us, due to which another complaint dated 18th March 2024 was filed, in respect of which FIR has been registered in crime number 108/2023.
Adu stay ಆಗಿದೆಯಾ?
Adu stay ಆಗ್ಲಿಲ್ಲ. Proceedings are going on in the said, in the
All right.
trial court,
Yes.
with respect to that. The petitioners have misused the stay order granted by this honorable court, and they are further harassing the respondent number 2, Your Lordship.
Yes.
For this second portion of the stay, second portion of that said
How do you
property,
demonstrate you are in possession of the property, sir?
my lord, the second portion of the property, it's sold off. We are saying that in 2004, the second portion of 25/3, and it has been sold, and this order that they claim reliance on was instituted in the year 2011, this suit.
ಏನ್ ಕಾಂಪೌಂಡ್ ಹೊಡೆದಾಕಿದ್ದೀರಾ?
ಹೌದು, ಇಲ್ಲ, stone slabs were.
My lord, they've even
laid
mentioned
on
it.
the site, my lords, that the stone slabs were removed and destroyed, causing loss of rupees 50,000.
If your lordship will turn to page number 32 of the main petition, on the spot measure, there's a specific finding that there is nothing on the said property and it is vacant land. There is no signs of any compound or any structure built on the said property. Even despite, subject to the
How
submission.
did
that
you
it
come in possession of the property?
Lord, we have sold that said property. This,
Sold
because they
that?
are trespassing, they have no title. They have no title
What is
whatsoever.
that judgment that the council is saying? OS 11,
No, we're not even we're not even parties to the said suit.
Not
Your
necessary,
Lord, Your Lordship.
not necessary.
Yes, ma'am.
Your Lordship, the same
What is the
survey
schedule,
number.
schedule in the, in OS 11, 1172 2011?
It is at page number 18, part and parcel of residential site bearing number 36, house list khata number 270, property number 25/3.
Which is the,
This,
which
in the
is
same
claiming?
survey number, there are several properties, Your Lordship. The petitioners may, they have, as per the information given to me, they have already sold their property that was there in that survey number. But for the sake of argument, it may be possible that they have a portion of the property in the same survey number. But that does not give them rights to trespass into our land, which is present in the same survey number, Your Lordship. They are saying that because we have a land in that survey number, we could not have trespassed into it because it is our property, which is a completely false submission, Your Lordship.
Survey number 25/3.
25/3.
Correct?
Yes, ma'am.
It is yours.
Yes, yes, my lord. 25/3 has been sold. That specific portion, because the portion that they claim that we are trespassing, the
Then
transaction.
it's a matter of trial.
Please, ma'am.
We'll dismiss it.
My lord.
It's a matter of trial.
My lord, for a civil suit, this transaction is purely of a civil nature. To claim that this portion.
No, that's civil in nature for other things. 447, 427 is not.
They haven't established their
447 is
title.
trespass.
My lord,
Title, I will record that this is the judgment and their vendor succeeded in the civil suit.
My lord, they haven't established their title and they're claiming criminal trespass in any manner.
ಮಾಡ್ತಾರೆ ಬಿಡಿ.
Without the
OS
foundation,
724 of 2020 ಯಾವುದು?
that is between the party that I sold the second portion of 25/3 and the petitioners herein. They had filed a suit for specific performance.
Your Lordship, even if the contentions of the petition is taken into account, it shows that the property is not even in their possession. So
ಇದು
they cannot
20
claim.
25/3 again,
Yes, yes, Your Lordship.
the second suit also.
So they themselves are stating that the property has been sold. It is not in their possession, which then does not
Have
give them
entered
any
into a
right to
transaction
claim.
with them and they simultaneously claim that we have trespassed. This is a third party transaction. And they are claiming that we have trespassed on their land without
That's
having
why it
any deed
becomes,
or title to
that
that.
is why it becomes a matter of trial. You want to file
So that
discharge,
is
you file.
This
Otherwise,
is my humble
I'll
submission. It's a
answer
matter
it now.
for civil dispute, my lord. Here, because title is in
Civil
question.
dispute is definitely, I'm not on that at all. It is only on 447.
Please, my lord.
Your
Because they haven't
447.
established title.
Your Lordship,
Established
subsequent,
that they will do before the concerned court.
Your Lordship, subsequently, they have once more trespassed into the same property.
And
Shows-
second complaint ಅಲ್ಲಿ charge sheet ಹಾಕಿದಾರಾ?
Sorry, Your
108 of 2020, another complaint.
The
ಅದರಲ್ಲೂ
case
charge
is
sheet
in court,
ಆಗಿದೆಯಾ?
Your Lordship. The
ಅದರಲ್ಲೂ
trial has
charge sheet
commenced.
ಹಾಕಿದ್ದಾರೆ.
Howದು? The
But
trial
even the
has
Mazar
commenced.
and even the Chachi say that there was no structure on the property as they claim that we have come down and broken their compounds
That's
in
a
any
matter
manner.
of trials. Yes. Second complaint number ಏನು? ಅದ್ರಲ್ಲಿ charge sheet number ಏನು?
Charge sheet, crime number is 108 of 2023, Your Lordship. Dated, FIR dated 18/3/2023. Charge sheet ಆಗಿದೆ, court ಅಲ್ಲಿ ಇದೆ, sir.
Charge sheet ಆಗಿದೆಯಾ?
CC number, just. ಇದೆ, one minute, sir. Sir.
ನೀನ್ judgment ಕೊಡ್ಬೇಕಾ? ಕೊಡಿ.
No, ma'am. Well, they haven't produced, it's only my humble submission, they haven't produced any documents regarding their title, that is sine qua non, before filing of this complaint. For criminal trespass.
Correct.
They cannot, the complainant claims we'll file a criminal complaint, then produce the title deeds, if any, if we found on a subject matter that has to be dealt
No,
with
it's
later
already,
in trial.
you've not seen the objections?
See, ma'am, the objection.
Then, where is the sale deed, madam?
Sale deed has not been annexed, Your Lordship. I will produce it, but the order of
Produce
this.
the judgment, but where is the sale deed?
I'll produce it on the next date of hearing, Your Lordship, if the court so requires.
Court requires Allah, it is necessary.
Yes, Your Lordship, I will
Yes.
produce.
Let her produce the sale deed.
Your Lordship, my humble submission is that the petitioners have also not produced any documents to show that they are still, they have the title of the property.
We will not get into that, we'll push it to trial if you don't produce appropriate documents. Huh? Because I have granted an interim order on this score that there cannot be a trespass into one's own property. The parties to the list to produce respective documents with regard to the possession and title of the property by the next date of hearing, title and possession of the property. The next date of hearing, list on Tuesday, the next Tuesday.
Interim order may be extended.
Interim order stands extended to the next date of hearing. Yes.
Date, Your Lordship.
Next.
19th, 20th. 20th January.
Much obliged. 36.
Before the petition in both the matters, ma'am.
Yes,
So, I'm told that my lord, charge sheet has been filed for IPC offences. And this.
IPC offences?
Yes, the lordship had granted a stay
Atrocities
against
Act
Atrocities
ಮಾತ್ರ.
Act.
ಹೌದು.
Atrocities, my lordship had passed and
There will
detailed
be
interim order. my
stay
lordship.
as granted in the aforesaid. ಅದೇ Atrocities Act ಮಾತ್ರ.
ಹೌದು.
So ಅದೇನಾಗಿಲ್ಲ.
ಅದೇನಾಗಿಲ್ಲ.
ಸರಿ, ಮತ್ತೆ ಚಾಲೆಂಜ್ ಮಾಡಿ ಅದನ್ನ.
I'll challenge the IPC offences, but
These petitions call in question registration of a crime in crime number
176 of 2023.
ಇನ್ನೊಂದು ಯಾವುದು?
ಒಂದೇ ಇದರಲ್ಲಿ in first petition accused number 10.
Serial number ಏನಿದೆ?
36 and
ಯಾಕೆ ಎರಡು petition?
We had approached this court by through accused number 10 for the first instance. ಆಮೇಲೆ ಅದರ
Other accused.
A1
So
to
now
11.
Atrocities Act is dropped.
It is not filed because there was a stay.
Because there was a stay.
Yes.
Now charge sheet is filed for the other offences.
Yes, ma'am, I'm told.
Then you file challenge that if you want to.
Yes, yes, sir. Liberty may be reserved for to challenge that, but so far as Atrocities Act, my lords, your lordship can pass order. Because already a detailed interim order has been passed.
Hello, respondent serve ಆಗಿದಾರಾ?
Served and unrepresented.
Yes.
Page 14 is the complaint.
Yes, government.
Liberty may be granted.
Liberty ಏನಕ್ಕೆ?
To challenge the charge sheet, my lords.
ಅದು ನಾನೇ ಕೊಡ್ತೀನಿ. ನೀವೇನ್ ಹೇಳ್ಬೇಕು? ನಿಮ್ದು ಇದ್ರಲ್ಲಿ ಕೇಸ್ ಏನ್ ಹೇಳಿ?
My lords, ಇದರಲ್ಲಿ the allegations of my lords, Let's complaint at page 14. Let's see, belongs to, let's.
Belongs to Bittu. Where is the complaint?
Complaint at page number 14, my lords.
14.
Last 3 lines, typed copy.
Sakalipura
Last 3 lines from the bottom.
ಸಾರ್ವಜನಿಕ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಚಿಕಿತ್ಸೆ ಮಾಡಿಸಿರುತ್ತೇವೆ ನಂತರ
ಅಲ್ಲಿ ಚಿಕಿತ್ಸೆ ಗಲಾಟೆ ಆಗಿಲ್ಲ. ಲಾಸ್ಟ್ 3 ಲೈನ್. ನೀವುಗಳು ಡ್ಯಾಶ್ ಜಾತಿಗೆ ಸೇರಿದವರಾಗಿದ್ದೀರಿ, ಆಶ್ರಮದ ಜಾಗದಲ್ಲಿ ನಿಂತುಕೊಳ್ಳುವುದು ಮತ್ತು ಜಮೀನಿನ ಬಳಿ ನಿಂತುಕೊಳ್ಳುವುದು ಯೋಗ್ಯತೆ ನಿಮಗೆ ಇಲ್ಲವೆಂದು ಹೇಳಿದ್ದು. ದಟ್ಸ್ ದಿ ಓನ್ಲಿ ಅಲಿಗೇಷನ್.
ಎಲ್ಲಿ ಇದು ಆಸ್ಪತ್ರೆ ಅಲ್ಲ?
ಇಲ್ಲ ಇಲ್ಲ ಇಲ್ಲ, ಇಟ್ ಅಲಾಟ್ಸ್ ದೇರ್.
ಎಲ್ಲಿ ಅಂತ ಹೇಳೋದೇ ಇಲ್ಲ.
ಎಲ್ಲಿ ಅಂತ ಹೇಳಲ್ಲ, ಜಮೀನ್ ಹತ್ರ ಅಂತ ಹೇಳ್ತಾರೆ. ಸರ್ವೆ ನಂಬರ್ 137ಕ್ಕೆ ಸಂಬಂಧ ನಿಮ್ಮ ಹತ್ರ ಮಾತಾಡಬೇಕು ಅಂತ ಕರೆದಿದ್ದಾರೆ. ಸಾರ್ವಜನಿಕ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಪ್ರಥಮ ಚಿಕಿತ್ಸೆ ಪಡೆದ ನಂತರ ಬಂದು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಪ್ಲೇಸ್ ಇಸ್ ಆಲ್ಸೋ ನಾಟ್ ಮೆನ್ಷನ್, ಟೈಮಿಂಗ್ಸ್ ಆಲ್ಸೋ ನಾಟ್ ಮೆನ್ಷನ್. ಓನ್ಲಿ
ಬಟ್ ಅಲಿಗೇಷನ್ ಆಫ್ ಅಸಾಲ್ಟ್ ಇಸ್ ದೇರ್.
ಅದಿದೆ ಅಸಾಲ್ಟ್ ಇದೆ, ಬಟ್ ನಾಟ್ ವಿತ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು ದಿ ಕ್ಯಾಸ್ಟ್, ಟೇಕಿಂಗ್ ಔಟ್ ದಿ ಕ್ಯಾಸ್ಟ್ ನೇಮ್. ಇವನ್ ದೇರ್ ಇಸ್ a counter complaint by us. ನಾವು ಹಾಕಿರೋ ಕಂಪ್ಲೇಂಟ್ ನಲ್ಲಿ ರಿಜಿಸ್ಟರ್ಡ್ 307 against them. That's why it has become a SC case, sessions case.
The petitioners are before this court calling in question registration of a crime in crime number 176 of 2023. Both these petitions are by call in question the same crime but are by different accused. Therefore, the same is taken together and considered by this common order. Heard the learned counsel appearing for the petitioner, the respondent, though served 3 years ago, has remained unrepresented. The state has preferred an application seeking vacation of the interim order. Therefore, the matter is taken up for its final disposal. The petitioners and the respondent complainant have a dispute with regard to certain lands. The dispute leads to an altercation between the two on a particular date, i.e. on 1/5/2023. It is the allegation in the complaint that around on 1/5/2023, the petitioners enter the land of the complainant and assault the complainant and hurl abuses taking the name of the caste. The complaint then becomes a crime. The complaint results in 2 crimes being registered, one by the petitioner against the complainant and the other by the complainant against the petitioners. The registration of a crime against the petitioners by the complainant forms the subject matter of these petitions. Since the entire issue has now triggered from the complaint, I deem it appropriate to notice the complaint. The complaint reads as follows. Page 16. The complaint, though narrates several instances of assault and other issues, the learned counsel for the petitioner would now restrict his submission in the case at hand to the one that is concerning the Atrocities Act, as there was an interim order granted only insofar as the offences under the Atrocities Act is concerned. The learned HCGP submits that charge sheet is now filed after investigation against these petitioners for all other offences except the Atrocities Act, as the offence under the Atrocities Act has been stayed at the hands of this court. Therefore, the consideration now in the case at hand is limited only to the offence under the Atrocities Act. The complaint is quoted herein above. In the complaint, the instance that draws the offence under the Atrocities Act are found in the last 3 lines. The last 3 lines would indicate that the petitioners have hurled abuses against the complainant by taking the caste of the complainant, and therefore it has become an offence under the Atrocities Act. The offences alleged under the Atrocities Act are the ones punishable under section 31R and S of the said Act. Section 31R and 31S read as follows. Section 31R and 31S mandate that the abuses should be hurled taking the name of the caste of the complainant with an intention to insult. The there is no complaint, there is no averment in the complaint that it happened in a public place or a place of public view, nor intentionally the said abuses were hurled. In that light, if further proceedings are permitted to continue against these petitioners for the offence under the Atrocities Act, it would run foul of the judgment of the Apex Court in the case of Hitesh Verma versus State of Uttarakhand, 2020 9 SCC page 710, 10 SCC page 710, paragraph 10 to 16 court mark. The Apex Court holds in the said judgment that the abuses must be hurled with an intention to insult, and they must be in a place of public view or in a public place. None of these averments are found in the complaint. Found in the complaint. Therefore, it can also not be the fact that civil suit in OS 52 of 2023 is pending between the parties is also a matter that is to be noted. In the light of the aforesaid circumstance, the offences under the Atrocities Act are clearly not made out in the case at hand, even on a perusal at the complaint, even on the perusal of the complaint. In that light, permitting further proceedings qua the offence under the Atrocities Act would run foul of the judgment as quoted here and above in the case of Hitesh Verma, and become an abuse of the process of the law only insofar as the offence under the Atrocities Act is concerned. In that light, the petition deserves to succeed in part by obliteration of the offences under the Atrocities Act. The liberty is reserved to the petitioner to challenge the charge sheet, if any, so filed on all other offences. All contentions qua the other offences shall remain open. For the aforesaid reasons, the following order. The petition is allowed in part the registration of a crime insofar as the provisions of the Atrocities Act stands quashed. It is made clear this court has not pronounced upon its finding on any other offence that is alleged against the petitioners in the crime or the filing of the charge sheet in the case at hand. Ordered accordingly.
And for the petitioners, my lord. The petitions are challenging the order of taking cognizance and issue of process passed by the Honorable Trial Court for the offences under the provisions of MMRD Act, my lord. Here in the case, my lord, petition 1 is the owner of the crusher, which is situated in survey number 153.
Cognizance.
Pardon, my lord?
What's wrong with the order of cognizance?
Absolutely, there is no case at all, my lord.
Page.
The page number, your lordship kindly turn to page 13, complaint, kindly be seen. Second para. Page number 13.
Where is the order of taking of cognizance, sir?
Yes, page 27.
Order is in page number 28, my lord. Order of taking cognizance. Page number 28. Here in the case, my lord, the petition number 1 is the owner of the crusher, my lord, which is situated in survey number 153, my lord, which is close to the government land, wherein illegal mining activities are being carried out by some unknown person. Since my crusher is close to survey number 194, my lord, on suspicious, the present complaint came to be filed. Page number 13 kindly be seen, my lord. Page number 13, second para. Page number 13, second para. Second para. ಈ ಸಂದರ್ಭದಲ್ಲಿ ಗ್ರಾಮಸ್ಥರು ಸದರಿ ಪ್ರದೇಶದಲ್ಲಿ ಗಣಿಗಾರಿಕೆ ನಡೆಸಿದರ ಬಗ್ಗೆ ನಿಖರವಾಗಿ ಯಾರು ತಿಳಿಸಿರುವುದಿಲ್ಲ.
Let the court reconsider.
No, your lordship kindly turn to spot measure. The entire spot measure falsifies the case of the prosecution.
No
your lordship kindly turn to spot measure.
We will direct the court to consider all the material and pass.
Your lordship kindly spot measure kindly be seen.
Yes.
Spot measure. Spot measure page number 40. The spot measure conducted on 26/8/2021, my lord. And after lapse of 4.5 months, the present complaint came to be filed. Complaint filed on 1/1/2020.
Spot measure leniದೆ.
Spot measure page number 41 kindly be seen, my lord. Last para. ಈ ಸಂದರ್ಭದಲ್ಲಿ ಗ್ರಾಮಸ್ಥರು ಸದರಿ ಪ್ರದೇಶದಲ್ಲಿ ಗಣಿಗಾರಿಕೆ ನಡೆಸಿದವರ ಬಗ್ಗೆ ನಿಖರವಾಗಿ ಯಾರು ತಿಳಿಸಿರುವುದಿಲ್ಲ. ತನಿಖಾ ಸಂದರ್ಭದಲ್ಲಿ ಯಾವುದೇ ಗಣಿಗಾರಿಕೆ ನಡೆಯುತ್ತಿರುವುದು ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ.
40
41, my lord, spot measure,
Page,
last,
page.
last para.
ಈ ಸಂದರ್ಭದಲ್ಲಿ ಗ್ರಾಮಸ್ಥರು ಸದರಿ
Yes.
ಪ್ರದೇಶದಲ್ಲಿ ಗಣಿಗಾರಿಕೆ ನಡೆಸುತ್ತಿರುವ ಬಗ್ಗೆ ನಿಖರವಾಗಿ ಯಾರೂ ತಿಳಿಸಿರುವುದಿಲ್ಲ. ತನಿಖಾ ಸಂದರ್ಭದಲ್ಲಿ ಯಾವುದೇ ಗಣಿಗಾರಿಕೆ ನಡೆಸುತ್ತಿರುವುದು ಕಂಡು ಬಂದಿಲ್ಲ.
Yes.
ಇದಾದ್ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿದ್ರ?
Yes, yes, my lord.
ಕಂಪ್ಲೇಂಟ್ ಜಿಯೋಲಜಿಸ್ಟ್?
Geologist, my lord. And this measure also signed by accused number 2, petition number 2, my lord, which is contrary to section 100 subclass 4 of the code of criminal procedure. And moreover, this measure, spot measure, falsifies the case of the prosecution.
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಸ್ಪಾಟ್ ಮಾಸರ್ ಬಗ್ಗೆ ಹೇಳ್ತಾರಾ?
Yes, my lord. Page number 13, second para kindly be seen, my lord.
13,
my lord. Complaint is in page number 11, relevant page 13, second para. ಈ ಸಂದರ್ಭದಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 13, my lord.
ಈ ಸಂದರ್ಭದಲ್ಲಿ ಗ್ರಾಮಸ್ಥರು ಸದರಿ
ನಡೆದ ಬಗ್ಗೆ ನಿಖರವಾಗಿ ಯಾರು ತಿಳಿಸಿರುವುದಿಲ್ಲ. ತನಿಖಾ ಸಂದರ್ಭದಲ್ಲಿ ಯಾವುದೇ ಗಣಿಗಾರಿಕೆ ನಡೆಯುತ್ತಿರುವುದು ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ. ಈ ಸಂದರ್ಭದಲ್ಲಿ ಹಾಜರಿದ್ದ ಕೆಲ ಗ್ರಾಮಸ್ಥರು ಮಾಜರಿಗೆ ಸಹಿ ಮಾಡಲು ನಿರಾಕರಿಸಿದೆ ಎಂಬುದಾಗಿ ಮಾಜರು ವರದಿಯನ್ನು ತಯಾರಿಸಿದೆ. Based on the spot measure, this complaint came to be filed, my lord.
Yes, government.
That the PCR filed by the my lord, the authorized officer before the.
ಅದೆಲ್ಲ ಆಯ್ತು ಸರ್, ಇದು ಫ್ಯಾಕ್ಟ್ಸ್ ಮೇಲೆ ಹೇಳಿ, ಅವ್ರೇನೋ ಹೇಳ್ತಿದಾರಲ್ಲ.
My lord, the measure, my lord, the neighbors, my lords, they will not speak about my lord.
ಅಲ್ಲ, ತನಿಖೆಯಲ್ಲಿ ಕಂಡು ಬಂದಿರೋದಿಲ್ಲ ಅಂತ ನೀವೇ ಹೇಳ್ತಾ ಇದ್ದೀರಾ. ನೈಬರ್ಸ್ ಬಿಡಿ, ದಟ್ ಇಸ್ ಯುವರ್ ಕೇಸ್. ನಿಮ್ಮ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲೂ ಅದೇ ಇರೋದು.
They secure the records and what is seized.
ವಾಟ್ ಇಸ್ ಸೀಸ್ಡ್? ಸ್ಪಾಟ್ ಮಾಸರ್ಲಿ ಅಷ್ಟು ಮಾತ್ರ ಇಲ್ಲ, ಪೂರ್ತಿ ಬೇರೆ ಎಲ್ಲ ಇದೆ.
ಎಲ್ಲ ಇದೆ, entire records are there.
Copy no
I have produced the entire records.
Spot measure copy is not served to me also.
ಅಲ್ಲ, entire it is there. Page number 40
is there ಅಲ್ಲ, it is not there.
Page number 40 ನೇ ಇಲ್ಲ ನನ್ನ ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ.
ಅಲ್ಲ, ನಮ್ಮ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಇದೆ.
ಅದೇ ಅವ್ರಿಗೆ ಗೊತ್ತಾಗದ್ ಬೇಡವೆ?
ಅಲ್ಲ, 40 ಅಲ್ಲಿ ಇದೆ. Produced along with the petition I have produced, my lord.
That is not there ಅಂತ ಇದ್ದಾರೆ ಅವರು.
40 pagination ಇಲ್ಲ.
The petitioner shall serve complete set of papers upon the council, learned HCGP.
ಅಲ್ಲ, it is there.
It is the case of the petitioner that it is the case of the council of the petitioner that the spot mahzar that forms the foundation for registration of the crime itself notices the following fact, page 41. The ಯಾರು ಕಂಡಕ್ಟ್ ಮಾಡಿದ ಮಾಜರ್?
Respondent, my lord.
The respondent complainant itself, complainant was the one who conducted the spot measure. If during investigation nothing is found against these petitioners or there is no mining activity in the said area as is alleged, it is ununderstandable as to how the crime could be registered and cognizance could be taken, crime could be registered. Above all, the order of taking of cognizance is bereft of reasons, as it does not indicate any factor except saying the perusal at the documents would lead to issuance of summons to these petitioners. The learned HCGP seeks a week's time to secure the papers and go through the same and make his submissions.
ಅಲ್ಲ, ಮಾಜರ್ is there, my lord. Yes.
Make his submissions. List the matter on 20th. In the event that no submissions would be made, appropriate orders would be passed on hearing the counsel for the petitioner. Interim order subsisting would continue till the next date of hearing. Yes. Next.
For the petitioner in 38.2 minutes.
38 minutes for the petitioner.
And
another 3 petitions are pending in respect of.
3 petitions.
Yes.
What is numbers?
That is the number 6906. 6906.
Number kodi sir alla, number kodi.
I will.
Tag this petitions. New organization.
Well, let's say appear for the petitioners in 38.2.
What are these matters?
This matter, my lords, is there's a property and I had entered into a joint development agreement with the owner. Then the agreement, my lords, is cancelled. There is a suit also filed by the accused number 1 against the complainant who is arrayed as defendant number 4 in the said suit. Suit is pending, my lords. He claims that he is the owner of a property by virtue of a gift. The accused number 1 claims owner of the property, saying that she has inherited it. And there is a suit which is pending. In fact, along with the PCR, my lords, he annexes the plaint, which is also a part of the record.
And after that crime is registered, for what offences?
Offences, my lords, are for
420,
418,
406.
420, 423, 506.
ಕೊಡಿ numbers ಕೊಡಿ ಎಲ್ಲ ಮುಗಿಸೋಣ ಒಂದೇ ಸರಿ.
Yes.
Who appears for the respondent? ಯಶಸ್ ಕೆ.
ಇದು
ಒಂದರಲ್ಲಿ ಚೊಕ್ಕಾರೆಡ್ಡಿ ಇದ್ದಾರೆ.
Yes, madam. In 3 cases are there, madam. I will give the numbers.
Numbers ಎಲ್ಲ ಕೊಡಿ. Tag these petitions along with so and so, list them all next Tuesday for admission. Interim orders, if any subsisting in these cases, shall continue till the next date of hearing. ಅಲ್ಲಿ heard so and so ಅಂತ ಮಾಡಿ, there is no representation on behalf of the complainant ಅಂತ ಮಾಡ್ಬಿಟ್ಟು ಆಮೇಲೆ ಮಾಡಿ. 30 ಎಲ್ಲ all cases.
39.
Appealing for petitioner. Accused number 1 and 2 have availed loan from the bank, your lordship, and they have defaulted the installments. PCR was filed against A1 and A2. Even FIR was filed against A1 and A2. Later in charge sheet, the petitioner was implicated as A4.
You are accused number 4.
Yes.
What is your role?
The petitioner has not signed any papers related to the loan, your lordship. I am the vendor. I have sold my property to A1 and A2. To A1.
Served unrepresented.
The
Yes, madam. Hey.
The DD was in my name and I have returned it to A1.
Why DD was in your name?
They have forged the documents and I was selling the property. In the sale deed, they have mentioned the DD, your lordship.
This is a PCR, is it? Where is the complaint?
Complaint is in page number
What is crime?
25.
That is same. Is government ನೋಡಿದ್ದೀರಾ?
Yes, my lord.
ಏನು?
My lord, sir, A4.
Therefore?
A4, my lord, though is not.
A4,
Yes.
yes.
Petitioner A4, my lord, though is not the owner of the property. My lord, sir, he executed the sale agreement as if he is the owner and received a sum of rupees 65 lakhs by way of sale agreement. My lord, CW4, my lord, the manager of the bank, 10, my lord, sir. He is the witness, my lord, who speaks about the, my lord, the transfer of amount from A1 to A4, my lord.
You have drawn the amount of 50 lakhs.
Yes, your lordship. Page number 78, I have returned it to A1.
Why did you get involved in this transaction?
They forced me, they begged for it, your lordship.
Begged for it?
They required it. Page number 78, Mahendra Singh, he's the A1. Entire amount of 47 lakh 13,659 has been returned to him.
No, your role is clearly found in the charge sheet also.
I am the owner, your lordship. Tax paid,
You
receipt is in
you are the owner of the property. You sell the property on what date, madam?
31, 2018.
31, 2018. To whom?
To A1, Mahendra Singh.
When was the loan availed?
The DD date was 24/1/2018.
24/1. After that, you have sold the property?
Yes, your lordship.
Make a synopsis.
Credited on
Make a
1 to
synopsis,
2000.
prepare and come next week. List next week in the same stage. Interim order subsisting will continue to the next date of it.
Okay.
40.
Proceedings, my lords, are against the wife, who is the partner of the firm under the Negotiable Instruments Act. So she is not an active participant in the
latest statement.
Please.
Last week.
Last
week.
This is last week. This is 24. Dilip
What
Hariraman.
24?
ಇದರಲ್ಲಿ my lords,
2025 December.
December.
ಅಷ್ಟೇನಾ? Who is the signatory?
Signatory is the husband. He is arraigned as accused number 2, partner of the firm.
You are accused number 1.
3.
3.
1 is my lords the
One
firm.
is the partnership
2
firm.
is the husband and 3 is the wife, my lords.
Yes, sir. Wife then.
My only concern is that
If
she's
wife is
actually
drawn, husband will come online.
actively participated.
Actively, just
That's
because she is the wife, she is actively participating.
Because she is the one who doing the business, all other things anyway. Check is signed by the
Signatory yaru, sir?
check is signed by the one of the partner,
One of the partner.
husband.
Partnership firm idu.
Partnership firm.
Both of your partners.
Both are the partners.
Both of us are partners.
Then
So, the judgment would, my lord, specifically state
That's with respect to company, but here in notice,
proprietorship concern is a different footing. Value irak sadhya illa bidi.
this is the partnership firm.
the explanation, my lords, under 141 would read, my lords, company means any body corporate and includes a firm or other association of individuals. And therefore, my lords, in
No, that's even the latest judgment
Yes, yes,
covers
please.
it. You have not got it, Ashton.
I apologize.
I have not got it.
In Dilip Hariramani, my lords.
No, that I am aware.
Please.
I am on the latest judgment. Yes, sir. Ashton.
At least only one
Paragraph
let,
ಏನಿದ್ರಲ್ಲಿ?
let the direction
Para 8, my lords, of the
Para?
judgment. Para 8.
let the direction is given to that because from past 2 years matter is here.
Will direct concerned court to conclude the proceedings. That's all right. Para 8 and 9 alla?
Please, my lords.
8, 9, 10. The petitioner is before this court calling in question the proceedings in CC 1295 of 2020 registered for offences punishable under section 138 and 142 of the negotiable instrument. Heard swords. The respondent is the complainant. The petitioner accused number 2. The accused number 3. The wife of accused number 2 and is said to be a partner in the company, a partner in the partnership firm.
Accused number 1.
The issue involved in the case at hand is an instrument which is signed by the husband in his individual capacity, the accused number 2, and not for the partnership firm. The horror,
ಇಲ್ಲ,
individual
for-
capacity.
ಇಲ್ಲ, my lords, in this.
Where is the check? Where is the check?
Check, my lords, last date of hearing.
ನೀವು
produced-
ಹಾಕಿಲ್ವಾ?
We have not produced it. Last date of hearing, they had given it to the court.
ಎಸ್ ವಿನಾಯಕ್ ಕೀರ್ತಿ ಎಲ್ಲಿದೆ ಚೆಕ್ ಕೊಡಿ. Partnership firm, sir.
ಇಲ್ಲ, my lords, this is
The
what, my lords,
judgment you gave
Please,
is judgment you gave or a judgment that is now the latest judgment also deals with in a partnership firm or in a company. If any director or a partner has issued the check in his individual capacity, he cannot be made liable or company cannot be made liable. Correct? Now, the now come to the judgment ke bani. Checks are not issued in his personal capacity or as or otherwise as a partner. As a partner ತಾನೇ
in
ಆಗಿರೋದು.
this, my lords, para 8, they would read the expression, every person is wide and comprehensive enough to follow that a person who does not bear out the requirements of in charge of and responsible of the company for the conduct of its business is not vicariously liable under section 141 of the NI. Burden is on the prosecution to
But
show.
this case was a check that was issued on individual capacity, is it?
Same thing, my lords, 4 other Supreme
Put it-
Court
put it
judgments, my
in.
lords, have held.
Give all that. ನೀವೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಚೆಕ್?
Timings.
Managing the affairs cell, yes. We'll see, we'll take this on Tuesday.
Please.
List, Tuesday, the next.
All of them would read, my lords, if they are not responsible for the day-to-day affairs of the business, they are not to be held.
Sometimes, see, there's a judgment of the apex court also which says that's a matter of trial, whether you're involved or not in the day-to-day affairs, but the latest judgment will throw some light.
This, my lords, is what I presume my lords were referring to. This is the latest judgment. Problem again is, my lords, the judgment which should read that in charge and responsible is by a two-judge bench. This judgment is also, my lords, by a two-judge bench. This, my lords, I must admit,
this
will
what
go
is-
against me.
This will go against
This will go against me.
That's
But, my
exactly
lords,
why I wanted this.
This will go against me, but, my lords, that is also passed by two judgments. This is also passed by two judgments. And there, my
We
lords,
will follow the
explanation-
later.
Please.
Anyway, Tuesday we'll do it.
Bless.
Entry model ಇದೆಯಲ್ಲ?
It was not extended, my lords.
Entry model subsisting shall, entry model granted earlier
ಇಲ್ಲ.
transaction.
Specific ಆಗಿ vacate ಆಗಿದೆ.
Specific ಆಗಿ vacate ಆಗಿದ್ರೆ ಇಲ್ಲ.
There is no specific order of vacation. There is an application
There is-
for vacating stay.
But
It is still pending.
answering that application vacate ಆಗಿದೆಯಾ?
Honorable
ಇಲ್ಲ,
Justice
ಇಲ್ಲ.
Nawaz Saab judgment.
ಒಂದ್ ನಿಮಿಷ ಯಾವತ್ತಿದೆ?
There is no order answering the application for vacating.
There is.
stay.
One minute.
Please.
ಒಂದ್ ನಿಮಿಷ. Vacated ಅಂತ ಬರ್ದಿದಾರಾ ಅಥವಾ ಏನು? But no settlement is arrived at.
That's next date.
ಯಾವ ಡೇಟ್ ವಿನಯ್?
On one day, my lords, I could not appear on that day, my lords. It was not.
No, not only that day, their colleague was.
ಯಾವ ಡೇಟ್ ಹೇಳಿ? On the ground that he is not well. And I have extended till a particular date. Again extended, again extended. Yeah, ಇದೇನಾಗಿಲ್ಲ. Not vacated by a specific order.
Honorable Justice Nawaz
Nawaz
has written,
said-
there is no compromise arrived.
No settlement has been arrived at. ಅಷ್ಟೇ ಬರ್ದಿರೋದು.
Yes.
ಆಮೇಲೆ entry ಮಾಡಿ.
Entry order extend ಮಾಡ್ಲಿಲ್ಲ ಅವತ್ತು. Anyway,
All
Tuesday.
right. Tuesday.
Please.
We'll close it on Tuesday.
Please.
Yes. Next.
41.
For the petitioner, please, my lords. The second respondent files a private complaint against the first accused for offense under 138. Those proceedings are stayed by my lords. My lords, to overcome that order, please, my lords, he files a PCR before the Mayhall court. In the 138 proceedings, he claims he is a resident of Mysuru. But whereas for this proceedings, please, my lords, he claims he is a resident of Vivekannagar and initiates a private complaint. And that has been referred for investigation.
ಅದೇನಾಯ್ತು 138 ಏನಾಯ್ತು?
ಅದು ಸ್ಟೇ ಆಗಿದೆ ಮಹಾಸ್ವಾಮಿ. My lords have
ಅದು
stayed.
ಯಾವುದು? Petition ಯಾವುದು?
My lords,
Which petition is that?
by mistake I have misplaced the file. I had gone through the entire petition. ಬೆಳಿಗ್ಗೆ ಕಳ್ಕೊಂಡಿದ್ದೀನಿ that.
ಬೆಳಿಗ್ಗೆ ಕಳ್ಕೊಂಡ್ಬಿಟ್ರ?
Please, my lords, I am applying. I take steps to secure the file.
ಒಂದು ಮಿಸ್ಸಿಂಗ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಡಿ. Yes. 363. Yes. ನೀವೇ ಇದು PCR ದ ಇದು?
Please, my lords, please here.
ಅಲ್ಲ 138 ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು ಯಾವ ಪ್ರೊಸೀಡಿಂಗ್ ಅಲ್ಲಿ?
My lords, in criminal petition before this honorable court, please.
Which is that? Number?
99, I'll secure. In
Yes.
criminal,
Next Tuesday again.
please. I'm sorry.
Get that number. Number ಕೊಟ್ರೆ ಆಮೇಲೆ ಟ್ಯಾಗ್ ಮಾಡಿಸ್ತೀನಿ ಬೇಕಾದ್ರೆ.
Please, grateful, please.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ನಂಬರ್ ಕೊಡಿ.
Please.
ಮೇಡಮ್ ನಂಬರ್ ಕೊಟ್ರೆ ಟ್ಯಾಗ್ ಇಟ್ ಅಂಡ್ ಸೇಮ್ ಇಯರ್.
23, please. my
Yes,
lords.
all right. Entry model subsisting would continue to the next date of year.
Grateful, please. I sorry, please.
Tag yes. Next.
42.
Petitioners, please, my lord. Dispute among the family members, my lord. Petition number 1 and 2, my lord, they filed a suit for partition, which was filed on 16th April 2021. During pendency of the civil suit, my lord, this is, my lord, on the interim night of 30th and 31st of January 2022, said to have been committed suicide, leaving one
306.
306. During pendency of civil suit, now partition suit file ಮಾಡ್ತೀವಿ. After 8 months of please.
Yes, sir.
There is a death note, my lords.
Which is
Death
left
note,
by the deceased.
ಹಿಂಸೆ ಆಗ್ತಾ ಇದೆ. ತಮ್ಮದೇ ಜಡ್ಮೆಂಟ್ ಇದೆ.
ಕೊಡಿ.
In fact,
ಒಂದು. ಕೊಡಿ.
the son of the deceased has also given the statement before the investigating officer,
ಕೊಡ್ಬೋದು.
who is CW2.
ಡೆತ್ ನೋಟ್ ಇದ್ದ ತಕ್ಷಣ ಅದಾಗ್ಬಿಡುತ್ತೆ ಅಂತ.
But the petitioners were responsible for the death of the deceased, my lord.
ಕೇಸ್ ಹಾಕಿದ್ರೆ ಅದು petitioners are responsible. Fighting a litigation is abetment to suicide.
Prior to that, my lord, petitioners had even attacked the deceased.
When?
Prior to his
Prior
death.
to institution of the suit.
Please, my lord. Please.
ಯಾವಾಗ?
But the specific date is not mentioned.
ಕಷ್ಟ ಅಲ್ಲ. 306 ಗೆ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿರ್ಬೇಕು, ಪ್ರಾಕ್ಸಿಮಿಟಿ ಇರ್ಬೇಕು, ಗೋಡಿಂಗ್ ಇರ್ಬೇಕು.
ಅವರು ತುಂಬಾ ಕೇಸಲ್ಲಿ ಅಪೇರ್ ಆಗಿದ್ದಾರೆ.
ಅದು ಗೊತ್ತು, ಅವ್ರ ಈ ಕಡೆ ಬರೋದಕ್ಕೆ ಇರೋದು ಮತ್ತೆ. Otherwise, he knows his limitations. The law is very clear. Yes, we'll close this.
Please.
The petitioner is before this court calling in question proceedings in CC 8977 of 2020.
SC number.
SCL number illide. SC 99 of 2023 registered for offence punishable under section 306 read with 34 of the IPC. The facts enumerated are as follows. Again, relation in nimge?
Brother-in-law.
Brother-in-law.
This is the brother-in-law of petition number 1, maternal uncle of petition number 2.
Allah, this is Ramaya commits suicide, is it?
Please, man, he is the brother-in-law of.
Adirli.
Please, Ramaya.
The second respondent is the complainant. Second respondent is the wife of one PT Ramaya. PT Ramaya and the petitioners are all members of the family who are fighting a litigation with regard to partition of the property. The petitioners 1 and 2 register OS 180 of 2021 for partition and seeking partition and separate possession. The suit is registered on 17/4/21 anta. So after the registration of the suit, after about 9 months of the conduct of the suit, the husband of the second respondent is said to have committed suicide, leaving behind a death note alleging that the reason for commission of suicide is the litigation that is drawn by the petitioners 1 and 2 are seeking partition of the property. This leads to registration of, on the death of the husband of the complainant registers a complaint which becomes a crime in crime number 14 of 2022 for offences punishable under section 306 read with 34 of the IPC. The police conduct investigation and file a charge sheet against these petitioners. Filing of the charge sheet is what has driven the petitioner to this court in the subject petition. The learned heard so and so. The learned counsel appearing for the petitioner would vehemently contend that the petitioners and the husband of the complainant, being members of the family, are before the court seeking partition of the property. Mere filing of a case against the husband of the complainant, arraigning him as a defendant in a suit, cannot mean, and his commission of suicide 9 months after the institution of the suit would not mean that the petitioners have abetted the commission of suicide against against the husband of the complainant. He would therefore submit that none of the ingredients of section 306 is met in the case at hand for further proceedings to be permitted to be continued. He would seek quashment of the proceedings. The counsel appearing for the second respondent complainant submits that it is not only the harassment that the petitioners have meted out to the husband of the complainant after the registration of the suit, but even before the registration of the suit, there was assault upon the husband of the complainant, and the death note brings about several factors of this nature, and the proceedings must not, he would submit that the proceedings must not be quashed and must be permitted to undergo, the petitioners must be should be directed to undergo trial and come out clean in this, the same. The learned HCGP would also toe the lines of the counsel for the complainant in drawing this court's attention to the statement and the death note which clearly pins down these petitioners for abetment of suicide. Therefore, submit that the petition be dismissed and the petitioners to come out clean in a full-blown trial. I have given my anxious consideration to the submissions made by the respective learned counsel and have perused the material on record. The aforenarrated facts are a matter of record. The relationship between the parties is again a matter of record. The husband of the complainant is the brother of the petitioners is not in dispute. They are at loggerheads with regard to a partition suit that is instituted in OS 180 of 2021. Seeking partition and separate possession. The suit comes to be instituted on 17/4/2021. The institution of the suit appears to have driven the husband of the complainant into frustration. And on 31/1/2022, yavatagid death?
Intervening night of 30th and 31st.
On 30th January 2022, when consumes poison,
hanging.
The husband of the complainant hangs himself and commits suicide, leaving behind a death note. The death note, though, indicates that the registration of the crime and the seeking partition of the property has led him to frustration and therefore is committing suicide, would not be enough circumstance to drive home the ingredients as is necessary under section 107 of the IPC, which is 107 of the IPC, which is necessary for as ingredients for an offence under section 306 of the IPC. Section 306 of the section 107 of the IPC reads as follows. Section 107 of the IPC deals with abetment, the abetment. Section 306 of the IPC punishes one who abets commission of suicide. Section 306 reads as follows. The interpretation of section 306 or 107 of the IPC need not detain this court for long, as jurisprudence is replete with the judgments rendered by the apex court from time to time, which have all been followed by this court, as to when it would become an offence under section 306 of the IPC to permit trial in such cases. The all entire set. You must Vinayak. We'll give you the list. So and so. In the light of the judgments rendered by the apex court, all of which are quoted here and above, the proceedings, if permitted to continue, notwithstanding the names of these petitioners under the death note, would become an abuse of the process of the law and result in miscarriage of justice. In that light, I deem it appropriate to exercise my jurisdiction under section 482 of the CRPC, obliterate the crime, obliterate the proceedings against these petitioners, allowed quashed quay the petitioners. Any other accused idara?
Only three.
Only three. Quashed.
Date of filing of the suit, my lad, 16th April, only 17th April.
16th April.
16th
Adon
April.
change ಮಾಡ್ಕೊಳ್ಳಿ. 17/4.
Great.
43.
Petitioner in this case. Not in this case, B report already filed, my lords. But I will ascertain whether objection filed or not. I will check it, my lords. Kindly after next week.
B report file ಮಾಡಿದ್ದೀರಾ?
Yes, my lords. File ಮಾಡಿದ್ದಾರೆ. Civil in nature ಅಂತ.
B report file ಮಾಡಿದ್ದೀರಾ? Protest petition ಹಾಕಿ cognizance ತಗೊಂಡ್ರೆ then you file. Why this now? The petitioner is before this court seeking the following prayer. The learned counsel for the petitioner submits that the police, after investigation, have filed a B report and the matter is before the concerned court. In the light of the filing of the B report, the petition in the form that it is present would not become entertainable. However, reserving liberty to the petitioner to knock at the doors of this court in the event of need, and the B report resulting in the event of need in future, with the said liberty, the petition stands disposed.
44.
Lordship, this is a 134.
134?
Sorry,
138.
138.
134.
My lordship, the respondent delegation is, my lordship, the petitioners have borrowed some material from the respondent, steel and cement and iron, worth of rupees 22.5 lakhs.
What is the ground, sir? Entry order idea?
Earlier entry order was Granted, my lordship.
Last date of hearing not extended. The last date
Extend
of
ಆಗಿದೆ.
hearing it is not extended, my
ಎಲ್ಲ
lord.
ಬೈ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿ ಅದ್ರಲ್ಲಿ ಏನಾದ್ರು ಆಗಿದ್ರೆ
3-4 days they are dragging the matter to argue the matters.
ಈಗ
Therefore,
ಮಾಡ್ತಾ
this
ಇದಾರಲ್ಲ, ಇನ್ನ ಡ್ರ್ಯಾಗಿಂಗ್ ಇಲ್ಲ.
because
I've listed it for admission only for disposal.
please.
Yes.
My lordship, prior to this, my lordship, in 2019, my lordship, petitioners, they are running a business, a label printing business.
What is your ground, sir?
ಅಲ್ಲ ಇದಕ್ಕಿಂತ ಮುಂಚೆ ಸ್ವಾಮಿ ಅವರು they have taken some financial from one person called Santosh, financial loan ತಗೊಂಡಿದ್ರು, hand loan. So per week ಗೆ 5% interest. You are charging 5%.
Tell a matter on merit, sir. What is the ground
So
here
when they
for
are failed
challenge?
to repay the, my lordship, that person has threatened and kidnapped the
Kidnapped?
petitioner, kidnapped. And regarding this, my lordship, the petition number 2 is she lodged a complaint before the
ಕಿಡ್ನಾಪ್ ಮಾಡಿ ಚೆಕ್ ಇಸ್ಕೊಂಡ್ರ?
ಅವಾಗ ಥ್ರೆಟ್ ಮಾಡಿ she has collected so many checks. ಅದಾಗಿ it's in page number.
Who the lady has
ಅಲ್ಲ first petition is second petition husband and wife.
ಇಬ್ರು ಸೇರಿ ಕಿಡ್ನಾಪ್ ಮಾಡಿದ್ರು ನಿಮ್ನ?
ಅಲ್ಲ ಇವರಲ್ಲ ಸ್ವಾಮಿ, the financier, they have borrowed the loan. So when they have failed to repay the amount, that person he has kidnapped and threatened and he has collected the check.
That is matter of evidence.
Yes. ಅದು FIR ಕೋಣ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ FIR was registered, my lordship.
ಏನಾಯ್ತು
ಅದು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಯ್ತು. They have filed a charge sheet.
ಅದ್ರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ.
ಅದ್ರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡಿದ್ರು. So in that case, my lordship, we have clearly said, including each check ಕೂಡ ನಂಬರ್ ಹಾಕಿದೀವಿ, and we have written a letter to the superintendent of police and bank everywhere. It is in page number annexure L, my lordship. The subject matter of check also involved, my lordship. Now 2019 alle complaint ಕೊಟ್ಟಿದ್ವಿ, a larger complaint in 2019.
When was the check presented?
2022 26/12/2022.
19 ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಎಲ್ಲಿದೆ?
Page number 60, annexure L, and page number J.
Page number
Page number 58, annexure J.
Annexure J.
This is a representation to the police inspector, my lordship.
Complaint, sir. Representation.
Sorry, complaint 29/7/2020. ಅದ್ರಲ್ಲೂ ಕೂಡ ಮೆನ್ಷನ್ ಮಾಡಿದೀವಿ.
Same checks, sir?
Same checks. 170056.
This is 29/7/2020 complaint. ಇದರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ?
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ, ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿ, and it is bank endorsement in annexure L dated 15/2/2023. As per letter dated, our letter, my lordship, as per letter dated 22/11.
Destroyed as per request. ಇಷ್ಟೊಂದು ಚೆಕ್ಸ್?
Almost all near to 95 checks he has collected.
ಆಮೇಲೆ ಚೆಕ್ ಪ್ರೆಸೆಂಟ್ ಮಾಡ್ರೆ? ಸೇಮ್ ಚೆಕ್ ಪ್ರೆಸೆಂಟೆಡ್?
ಇವ್ರಿಗೆ ಗೊತ್ತೇ ಇಲ್ಲ ಸ್ವಾಮಿ, ಯಾರು ಅಂತಾನೆ ಗೊತ್ತಿಲ್ಲ ಚೆಕ್ ಪ್ರೆಸೆಂಟ್ ಮಾಡಿರೋ. He says he has supplied iron, steels and cement. Invoice ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದೊಂದು except that nothing is produced. He resides in Arkulgodu. ನಾವು ಬೆಂಗಳೂರಿಗೆ ಸಪ್ಲೈ ಮಾಡ್ತೀವಿ ಅಂತ ಸ್ವಾಮಿ. ಸಿಮೆಂಟ್ ತಗೊಳಕ್ ಇಲ್ಲಿಂದ Arkulgodu, there is no necessary for that. And he has not produced delivery challan or demand letter, nothing.
Where are the proceedings of charge sheet ಅಲ್ಲಿ ಹಾಕಿರೋದು ಎಲ್ಲಿದೆ? ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆಯಾ?
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿರೋದು ಇಲ್ಲಿದೆ ಸ್ವಾಮಿ. ಆ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ notice was issued, but complainant she has delayed to file the wakalat. ಅವ್ರಿಗೆ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ, by oversight ಇದ್ರ ಆರ್ಡರ್ ಆಲ್ರೆಡಿ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ವಾಶ್ ಆಗ್ಬಿಟ್ಟಿದೆಯಾ?
ಕ್ವಾಶ್ ಆಗೋಗಿದೆ. ಅವ್ರಿಗೆ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ, ಅವ್ರಿಗೆ ಫೈಲ್ ಮಾಡಿದ್ರೆ
ವಾಶ್ ಆಗಿರೋ ಆರ್ಡರ್ ಅಲ್ಲಿ?
ವಾಶ್ ಆಗಿರೋ ಆರ್ಡರ್ have not produced that, my lord.
ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ? ಅದೆಲ್ಲ ಅವ್ರ ಹತ್ರ ಇರುತ್ತೆ, ಕೊಡಿ.
See, my lordship, I'm not related to that person. See, this is a commercial transaction between the complaint and the accused. Herein in the petition and the respondent, they are saying that one Satish Kumar, who is the financier, they have borrowed the money from him. He was forcibly collecting the 97 checks and ಹೇಳಿ. So see, there is no relating to these transactions, my lordship. See, only for the purpose of escaping from the liability of these 138 proceedings, they are creating this theory, my lordship. That was
in 2019 itself we have given a complaint and a representation.
They were unrepresented.
Court has considered that also here.
They are unrepresented. Even service of notice.
Order ನೋಡಿದಿರಾ?
ಅದು ನನಗೆ ಫರ್ನಿಶ್ ಮಾಡಿರಲಿಲ್ಲ ಸ್ವಾಮಿ.
ನಿಮಗೆ
even
unrepresented.
ಅಲ್ಲ, even they have not In notice, they have not said when that check was issued and where it was issued. ಯಾವ ಕೊಟ್ಟಿದ್ರು ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ರು ಅಂತ ಕೂಡ ಮೆನ್ಷನ್
There is
ಮಾಡಿಲ್ಲ.
some GST bills and eBay bills, everything
And for
is
that
there,
also
my
we
lord.
given complaint, my lord.
They have to prove in the
Like,
trial.
immediately
before the trial
next
court.
month when it
Not
has
to match
reflected in our GST, we have raised a complaint before the GST authority. ಇದು ಯಾವ್ದೋ ಮಿಸ್ ಆಗಿ ಬಂದಿದೆ ನಮಗೆ ಗೊತ್ತೇ ಇಲ್ಲ ಇದು ಯಾವ್ದು ನಾವು ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿ. It's in page number 63.
After filing the case.
No, sir, this finding goes against you here. Para 16, Justice Sandesh Avardu.
Lordship, in 2019 itself, we have lodged a complaint. Specifically, we mentioned the case number, check numbers.
It is
ಯಾವ್ಯಾವ check
nothing
miss
but an
ಆಗಿದೆ ಅಂತ
offshoot of the complaint against the proceedings initiated against respondent number 2, 130. ಇದು ಈ ಕಂಪ್ಲೇಂಟ್ ಆಮೇಲೆ ಅಂತ ಹೇಳ್ತಾರೆ
ಯಾವ್ದು ಮಾಡಿ?
138 ಹಾಕಿದ್ ಯಾವಾಗ?
In 2023.
My lord, that is
ನಮ್ದು
different
ಬಂದು
between
2019, 18 ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಆಗಿರೋದು FIR.
the petitioner and the someone person. This is different. This petition, the respondent is different.
ಇದು ಟಿ ದಿವ್ಯಾ ಯಾರು? ಸತೀಶ್ ಕುಮಾರ್ ಯಾರು?
We don't know Satish Kumar.
Lordship,
They are saying that they are one Satish Kumar.
ಅವ್ರ
has
ಮೇಲೆ
a
ಅವ್ರ ಮೇಲೆ
collecting
FIR
force.
ಮತ್ತೆ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿತ್ತು.
One minute, sir, one minute. ಇಲ್ಲಿ ಕಂಪ್ಲೇನೆಂಟ್ ಯಾರು? ಚೇತನ್,
Please,
ಸ್ಟೀಲ್ಸ್ ಅಂಡ್ ಹಾರ್ಡ್ವೇರ್.
please.
ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಏನ್ ಸಂಬಂಧ?
ಇಲ್ಲ ಸ್ವಾಮಿ,
nowhere
that
relating
person
my
has, ಅಲ್ಲ ಅವರು ಥ್ರೆಟ್ ಮಾಡಿ ಚೆಕ್ ನ ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ದು ಚೆಕ್ ನ he has handed over to him. 2019 ಅಲ್ಲೇ ನಾವು ಲಾಡ್ಜ್ ಮಾಡಿದ್ವಿ ಕಂಪ್ಲೇಂಟ್.
ಎಲ್ಲ ಮ್ಯಾಟರ್ ಆಫ್ ಟ್ರಯಲ್. ಚೆಕ್ ಸಿಗ್ನೇಟರಿ ನೀವೇನಾ?
That is not dispute.
ಚೆಕ್ ಸಿಗ್ನೇಟರಿ
No,
ನೀವೇನಾ?
blank check, that is our allegation, my lordship. Forcefully they have taken a
Forcefully ಅಂದ್ರೆ it's a matter of trials. We'll answer it. The petitioner is before this. ಒಂದೇ petition ಎಷ್ಟಿದೆ?
On the petition.
Serial number 43 ಅಲ್ಲ?
44.
The petitioners accused 1, 2 and 3 are before this court, calling in question proceedings in CC 358 of 2023. The heard so and so. The petitioners and the respondent have a transaction amongst themselves. The transaction is with regard to supply of cement.
Iron.
Cement, iron.
Steel.
The transaction is with regard to supply of steel.
Page number
In
61.
furtherance of the transaction, it transpires that the petitioner had issued ಎಷ್ಟು ಚೆಕ್? ಒಂದೇನಾ?
One check.
Had issued a check for an amount of rupees 22,50,000. The check when presented is dishonored on account of want of funds. This leads the complainant to take steps under the Negotiable Instruments Act and later invoke the provisions of section 200 of the CRPC in registering a private complaint for offense punishable under section 138 and 142 of the Negotiable Instruments Act. The concerned court takes cognizance of the offense and issues summons, and therefore the petitioners are before this court challenging the said orders passed by the concerned court. The learned counsel appearing for the petitioner submits that the checks bearing certain numbers were stolen. The checks were secured from the hands of these petitioners after abducting them and forcibly taking their signatures on the check. On that ground, the petitioners had already registered a crime, and the police, after investigation, had filed a charge sheet against a particular person, one Satish Kumar S, who had threatened and taken the signatures on the checks. It is the case of the petitioner that they said Satish Kumar has handed over the checks to the present complainant, and therefore the proceedings should not be permitted to be continued. The learned counsel appearing for the respondent complainant submits that the proceedings against Satish Kumar was challenged in criminal petition 10436 of 2023. The coordinate bench of this court has quashed the proceedings against Satish Kumar, finding no offense of section 384 of the IPC, as the ingredients of section 383 had not been met in the case at hand. The said judgment has become final is the submission of the learned counsel appearing for the respondent complainant. He would otherwise contend that the case, the complaint so registered or the charge sheet so filed has nothing to do with the present complainant, as the parties to the list are entirely different. He would submit that the check is, the issuance of check is admitted. Once that is admitted, it becomes a matter of trial. I have given my therefore narrated, anxious consideration for all matter. The transaction between the petitioner and the respondent is a matter of record. In terms of in furtherance of the said transaction, issuance of a check on 26/12/2022 is also a matter of record. The plea set up by the petitioners, the accused, is that they were abducted and they forcibly a signature on the check was taken would undoubtedly become a matter of trial. This court, exercising jurisdiction under section 482 of the CRPC, cannot now telescope its imagination onto what has happened prior to issuance of the check unless the parties would lead evidence. Insofar as the quashment of the proceedings are concerned, as submitted by the learned counsel, insofar as the registration of the crime and the filing of the charge sheet is concerned, as submitted by the counsel appearing for the respondent, it is between some other party. It is not between the petitioner and it is not between the complainant, the present complainant, though the petitioner remains the same. The finding of the coordinate bench would become necessary to be noticed in the case at hand, as the submission is with regard to kidnapping, extortion, and forcibly taking signatures on the check. The coordinate bench observes as follows. Para 16, page 16, 17 flag. In the light of the said finding, as also the emphatic submission of the counsel for the petitioner that they were abducted and forced to put their signatures on the check, would undoubtedly require evidence. This undoubtedly require evidence which this court would not entertain in exercise of jurisdiction as observed here and above under section 48 of the CRPC. Therefore, the petition lacking in merit stands rejected. All contentions remain open to be urged before the concerned court. Ordered accordingly. Yes.
45.
Appearing
Yes,
for
ma'am.
the respondent number 2, my lord.
Lord, I represent the petitioner, my lord. My lord, a private complaint was filed, my lord, without.
Interim order. Interim order idea.
Yes, my lord. It's there.
My interim order.
That is the order by.
Not mine. Yes.
Yes, yes.
ಅಲ್ಲ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಯಾಕೆ ಕೇಳೋದು ಅಂದ್ರೆ
ಅದೇ, ಅದೇ.
4 ಪೇಜ್ ಬರೆದ್ಬಿಡ್ತೀನಿ.
My lord, initially,
becomes
my lord,
easy.
yes, my lord. A private complaint was filed, my lord, without compliance of 156(3). That I cannot use it now, my lord, by virtue of the recent
Latest
judgment.
judgment.
Yes, my lord. Now I will have to fight the case on merits only. My lord, allegation is that, my lord, the property was belonging to one Bhadrama. My lord, subsequently.
Ready?
Yes, my lord.
Yes.
Yes, please. But in the year 2005, my lord, one another lady has sold the property to petition number 123. Petition number 123 are the purchasers of the property. Petition number 4 and 5 are the witnesses to the sale deed. Petition number 5 died during the pendency of this proceeding. Now 1 to 4 are on record. But so far as this very same land is concerned, it was acquired by the BDA in the year 1974-75. And LAC proceedings was held and award was passed and the complainant hearing.
It's crime of 2014.
Yes, my lord.
Charge frame ಆಗಿರ್ಲಿಲ್ವಾ ಇನ್ನು?
Pardon, my lord?
Charge frame ಆಗಿರ್ಲಿಲ್ವಾ?
ಅಲ್ಲ, charge ಆಗಿರ್ಲಿಲ್ಲ. Charge ಆಗಿರ್ಲಿಲ್ಲ.
It was framed on 2016, my lord.
When?
2016, after investigation.
Charge sheet ಅಲ್ಲ madam.
Madam.
Charge sheet is filed.
What had happened, my lord?
Wait, let her tell why. Yes. Charge frame ಆಗಿದೆ ಯಾವಾಗ ಹೇಳಿ?
No, my lord, not frame.
Yes, government.
Earlier, the petition was filed, my lord.
No. See, earlier crime register ಮಾಡಕ್ ಫೈಲ್ ಮಾಡಿದ್ರು, ಆಮೇಲೆ CC 2016.
Yes, my lord.
Charge frame ಆಗಿದೆ. That's a separate proceeding.
No, this is second round. Earlier.
ಆಯ್ತು, crime challenge ಮಾಡಿದ್ರೆ withdraw ಮಾಡಿದ್ರೆ ಹಾಕಿದೀರಾ?
No.
Then?
No, earlier the cognizance was quashed by this court and remanded the matter back to the trial court again. And a second time also cognizance was taken.
Where is the order of cognizance now?
That could be seen at.
Page number 56, my lord.
Page number 141, my lord.
141 to 146.
Present order of cognizance.
Present order, my lord. Present order.
141 na?
Yes. Oh, sorry.
Page number 56, my lord.
Sorry.
Sir, 141 is court order.
Page number 56, my lord.
Yes. Sorry. The present order is at 56, my lord. This is the present order.
Now, what is the offense?
That offense alleged under 420, 465, 467, 471. Allegation is that one another lady has sold the property instead of the Bhadramma. The property was belonging to one Bhadramma, my lord. According to them, she died in the year 1969. In the year 2005, one another lady, by calling herself as a Bhadramma, has sold the property to petition number 123. These are the bona fide purchasers. We do not know whether that lady was alive or not. But the fact of the matter is that this very same property was acquired by the BDA, my lord, in the year 1974-75. The complainant herein, they have taken the money also, award was passed, and they have taken the compensation. Subsequently, they have filed a suit for partition on the in respect of the very same property. BDA has participated in the proceedings, and the plaint was rejected on the ground that since the BDA has already passed an award and they have taken the compensation, they have no right. My submission is, my lord, since the matter is already, the BDA has already taken over the property, and now the property is with the BDA, they cannot institute the complaint against us.
Now, who is the complainant?
Now that
complainant is Muni Raju.
Yes, my lord.
Who is Muni Raju?
He is the grandson of one Tirumalamma, who is the daughter-in-law of Bhadramma.
Yeah.
Bhadramma was the original landlord. Her daughter-in-law Tirumalamma was the complainant initially. She also died. Thereafter, our grandson has come into picture. The very same.
Now the property is acquired by the BDA.
Yes, please.
When?
Well, in the year 1974 itself, it was acquired, and the proceedings was initiated by the very same complainant hearing. That is at annexure 134, my lord, decree, judgment and decree.
134.
Yes, ma'am. It starts from. It starts from 118, my lord. It starts from 118. The plaint was rejected on the ground that they have no right, subsisting right, since the BDA is already acquired.
Suit is dismissed.
Yes. So my submission is, my lord, since they have no subsistence right, they cannot file a complaint against us. Since the matter is now with the BDA, BDA has already acquired the property. If at all, if there is any grievance, let the BDA file a case against us.
Why are they against you now?
They say that it is still their property. They have suppressed with regard to the acquisition of the property by the BDA. They say that it is their property.
Why are you arrayed as accused, sir?
Yes,
sir. All of you arrayed as accused.
Yes, they make an allegation that it is their property and somebody else has sold this property to us. We are the purchasers of their property through somebody.
But you said the property is already acquired by the BDA.
Yes, please.
You are not in possession of the property?
We are in the possession by virtue of the registered sale deed executed by one in the year 2005, my lord.
2005.
Yes.
Acquisition 78 ಅಂತ ಇದ್ದೀರಾ?
74, 78
ಮತ್ತೆ acquisition 2005 ಅಲ್ಲಿ sale deed ಹೆಂಗ್ ಬಂತು ನಿಮಗೆ?
By suppression of all those facts, my lord, they have sold to us. Now we are the victims now. My submission is, my lord, there is already a judgment and decree against to them stating that they have no subsisting right. Since the property is already acquired by the BDA, they cannot institute a proceedings against me.
Yes.
Lord, for a moment, kindly come to the page number 29, my lord. The charge sheet of Abetment, my lord.
Yes.
Lord. 29/9/1985 ಮತ್ತು ದಿನಾಂಕ 7/6/1992ರಂದು 2 ನೋಟಿರಿ ಜಿಪಿಎ ಪತ್ರಗಳ ಮೂಲಕ A3 ಆರೋಪಿತಿಗೆ ಸೈಟ್ ನಂಬರ್ 4 ಅನ್ನು ಪಿತ್ರಾರ್ಜಿತ ಸ್ವತ್ತೆಂದು ನಮೂದಿಸಿಕೊಂಡು ಅಧಿಕಾರವನ್ನು ಬಿಟ್ಟುಕೊಟ್ಟರೆ ಪತ್ರವನ್ನು ಮಾಡಿಕೊಡುವುದಾಗಿ ಆಧಾರದ ಮೇಲೆ ಆರೋಪಿತರು ಬಿಬಿಎಂಪಿಯಿಂದ ಕಟ್ಟಡದ ನಕಾಶೆ ಮಂಜೂರು ಮಾಡಿಸಿಕೊಳ್ಳಲು ಹೋದ ಸಂದರ್ಭದಲ್ಲಿ ಮೂಲೆ ಖಾತೆದಾರರು ಬಂದು ರಿಜಿಸ್ಟರ್ ಮಾಡಿಕೊಡದೆ ಹೊರತು ಮಾಡಿಕೊಡದೆ ಹೊರತು ಮೂಲ ಖಾತೆದಾರರಾದ ಶ್ರೀಮತಿ ಭದ್ರಮ್ಮ ದಿನಾಂಕ 17/10/1969 ಮರಣ ಹೊಂದಿದ್ದರಿಂದ ಆರೋಪಿತರು ಎಲ್ಲ ಸೇರಿ ಸಾಕ್ಷಿರವರಿಗೆ ಸಂಬಂಧಪಟ್ಟ ಸೊತ್ತನ್ನು ಲಪಟಾಯಿಸುವ ಸಂಚು ರೂಪಿಸಿಕೊಂಡು ಮರಣ ಹೊಂದಿದ ಶ್ರೀಮತಿ ಭದ್ರಮ್ಮ ಬದಲಿಗೆ ಬೇರೊಬ್ಬ ಹೆಂಗಸನ್ನು ಕರೆತಂದು ಆಕೆಯನ್ನೇ ಭದ್ರಮ್ಮ ಎಂದು ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಕಚೇರಿಯಲ್ಲಿ ಪರಿಚಯಿಸಿ ದಿನಾಂಕ 30/8/2005 A2 A3 ಸೈಟ್ 3 ಮತ್ತು 4 ದಿನಾಂಕ 23/7/2000 A1 ಆರೋಪಿಗೆ ಸೈಟ್ ನಂಬರ್ 5 ಬೆಂಗಳೂರು ಉತ್ತರ ಸಬ್ ರಿಜಿಸ್ಟ್ರಲ್ಲಿ ನೋಂದಣಿ ಮಾಡಿರ್ತಾರೆ. ಈ ಎಲ್ಲಾ ಸಂದರ್ಭಗಳಲ್ಲೂ ಸೇಲ್ ಡೀಡ್ಗಳಾಗಿ ಸಾಕ್ಷಿದಾರಾಗಿ ಆರೋಪಿತರ ಗಂಡಂದಿರಾದ A4 ಮತ್ತು A5 ಸಹಿ ಮಾಡಿರ್ತಾರೆ. ಹೀಗೆ ವಂಚನೆಯಿಂದ ಪಡೆದ ದಾಖಲೆಗಳನ್ನು A3 ಆರೋಪಿತೆ ನೈಜವಾದದೆಂದು BBMPಗೆ ಸಲ್ಲಿಸಿಕೊಂಡು
ನೀವು ಪೊಸಿಷನ್ ಇದ್ದೀರಾ?
Malad, we are in position, Malad. Malad, in the 1978-79, Malad, entire land was not acquired, Malad. Only 16 guntas was acquired, Malad.
The remaining portion you are in possession.
Please, Malad, for a moment, Malad, in the.
Withdrawn the compensation. For that he has already withdrawn the compensation also.
Who?
His complaint.
Bhadrama, sir.
Bhadrama.
Malad, they are in annexure, Malad.
What is the suit pending?
Malad, annexure came, Malad.
Suit pending is it?
No, no.
Disposed.
Their suit is
Dismissed.
Dismissed, Malad, that has been challenged by the CRP. CRP is pending. Malad, annexure came, Malad. The acquisition only 16 guntas, Malad. Second, Malad, that I am the Katadar of the survey number 17/3, measuring 16 guntas situation Gadanali village, Kasva Hubli. Only 16 guntas has been acquired, Malad, remaining as land with the Bhadrama, Malad. And moreover, Malad, in this case, Malad, in the year, Bhadrama is died in the year 1969 itself, Malad.
She comes before the sub registrar and signs.
Sign, Malad. By the impersonation, Malad, the
They
petition.
are the purchasers.
They are the purchaser, Malad.
ಅವ್ರದ್ದೇನ್ ತಪ್ಪು?
They himself as a.
That lady has not been made as a party to the criminal proceedings.
ಸತ್ತೋಗಿದ್ದಾರೆ ಅಂತ.
Allala, so the person who had sold to us has not been made as an
Who is your vendor?
Bhadrama, yes.
Who is your vendor? Which is that person?
Bhadrama.
Bhadrama is died in 1969.
In our name, somebody else has sold anta, that is the allegation, my lord. The living person has been sold anta. My submission is, my lord, since there was no subsisting right.
My lord, in the, my lord, at the time
All
of
this maze of facts will not interfere.
At the time of the taking the Kata, my lord, they are says that, my lord, Pitratitavagi Vanda Sotto, but Bhadrama has purchased the property, my lord. In the year 1947 itself, my lord. They are also not disputed that we are the purchase of the property, my lord.
Who came before the sub registrar?
Bhadrama, my lord.
Some other lady has taken.
Who is that impersonator? Who nobody knows? Who got it? Who got her?
This petitioner.
This petitioner has got it, my lord.
That we are the purchasers, my lord.
Oh, the purchasers, sir.
We are the purchasers. They should have made.
How did you find Bhadrama?
Bhadrama was the original owner.
How did you find her?
My lord, according to that lady, my lord, she is the
Now,
owner.
2-3 things. The land is already acquired.
Yes, my lord.
All right, they had filed a suit and that suit is dismissed.
Yes, yes.
And there is a CRP pending against that. It's a different factor. Now, you have purchased the property in the year 1985.
2005.
2005.
Yes, my lord.
By, your
Bhadrama.
vendor is one Bhadrama,
Yes.
who has died, admittedly died in the year 1969.
That is according to them, my lord.
But death certificate.
That is certificate has been produced. At the time of the investigation, my lord, police have given a death certificate to the police, my lord. Otherwise, I will produce the next date of hearing.
ಎಲ್ಲ next date of hearing ಆಗಲ್ಲ. Yes.
I
Yes,
don't have-
government.
I don't have death certificate of present, no, my lord.
Lord, in the original suit, my lord, they wanted to implead us as also the parties. That application was also came to be rejected. Since the matter is now with the BDA, my lord, BDA seized the property. Now, my lord, they cannot.
These are maze of facts, sir. The only issue is a property that is acquired by the BDA is now being fought by impersonators.
Yes, please.
So that requires trial. That's all.
So my submission.
Bhadrama ಸತ್ತೋಗಿದ್ದಾರೆ ಅಂದ್ಮೇಲೆ 2005 ಅಲ್ಲಿ where did she spring?
That is their case, my lord. That is their case.
Death certificate ಇದೆ ಇಲ್ಲಿ. ತಿರುಮಲಮ್ಮ ಯಾರು?
Tirumalama is the daughter-in-law of that Bhadrama.
She is also died.
She also died. Now
She is also dead, sorry.
Third generation now. Bhadrama died, her daughter-in-law, Tirumalama died, and thereafter her grandson has come into picture now.
The issue is with regard to forgery, impersonation and all
That
those
is the
things.
allegation, ma'am. That is the allegation.
That is the allegation. It should be tried, Alla Prakash.
Like it could be taken up next week, my lord. I will also secure the entire charge sheet. I will also try to point out if there are any.
Because if it definitely forms maze of facts. For editorial.
I will go through the charge sheet and I'll make.
Nodi.
Yes.
I'll grant you time next week. Death certificate
Yes.
produce ಮಾಡಿ
Yes,
ಭದ್ರಾಮನ್.
I will produce.
ಭದ್ರವಾಗಿದೆಯಾ?
Yes, ma'am.
ಸರಿ. Tuesday. Next Tuesday.
My lord, could be taken up 21st, my lord.
20th. Only Tuesday.
20th.
23 matters only Tuesday.
My lord, 20th, there is already 2 cases posted, my lord. It could be any other day, my lord.
13th or 20th?
13th.
13th.
That is also.
Yes, ma'am.
Interim order may kindly.
Interim order subsisting would continue to the next date of hearing. Yes. Otherwise, kashta ಇದೆ Prakash.
Yes, please. At least one of the accused is only a witness to the sale deed, my lord.
Adanna will quash it, not a problem.
Yes.
Who is witness, they will also not come in the way, can't be. Witness, ಈಗಲೇ quash ಮಾಡ್ತೀನಿ. If you want, I'll quash it and send the others to trial.
Witness also husband of the.
I will go through the charge sheet.
But
and I will
anyway,
say.
witness ಮಾತ್ರ.
I'll go through.
No,
the
but
charge
ready.
sheet. Yes. Great.
List 13th interim order subsisting will continue to the next date of hearing.
46.
My lordship, representing the petitioner, my lordship. And before the trial court accused number 3, my lordship.
Theft.
My lordship, I am the purchaser, my lordship. A1 and A2 is the car dealer, my lordship. We purchased the vehicle at the amount of rupees 35 lakhs. At the same day, we paid 15 lakhs to accused number 2 account only. Brought the vehicle in Bangalore and went out my native place, my lordship. After lapse of 10 months, my lordship, original owner of the vehicle filed the complaint. Kindly see the
Complaint what? Theft.
Theft. First,
Where is the?
Kindly see, my lordship, page number 13, my lordship.
First sale ಇದೆಲ್ಲಿದೆ invoice.
Invoice.
ಇಲ್ವಾ? ಮತ್ತೆ ಸುಮ್ನೆ ಕೊಟ್ರ ಹಿಂಗೆ?
Second vehicle, my lordship.
Second vehicle.
Used vehicle.
ಅಲ್ಲ used vehicle ಗೆ ನೀವು ಸೇಲ್ ರೆಸಿಪ್ಟ್ ಅಂತಿರಲ್ವಾ?
We purchased the vehicle in the.
Form 2930.
Yes, yes, my lord. That is our difficulty. My lordship,
That is the difficulty.
my lordship, kindly see first
ಮೂರು
2
ಕೊಡಿ
lines.
ಸರ್. ಒಂದು ಸೇಲ್ ರೆಸಿಪ್ಟ್, ಇನ್ನೊಂದು ಟ್ರಾನ್ಸ್ಫರ್ ಫಾರ್ಮ್ 2930 ಎರಡು ಕೊಡಿ, ಕ್ವಾಶ್ ಮಾಡ್ತೀನಿ.
See first 2 lines, my lordship, permit me to read.
ಹೇಳಿ ಸರ್.
Ink page number 13, my lordship. ಈ ಮೂಲಕ ತಮ್ಮಲ್ಲಿ ಕೋರಿಕೊಳ್ಳುವುದೇನೆಂದರೆ ದಿನಾಂಕ 9/1/2022 ಮಧ್ಯಾಹ್ನ 12:30 ಗಂಟೆಗೆ ನಾನು ಮೇಲ್ಕಂಡ ನನ್ನ ಕಾರನ್ನು ಲ್ಯಾವ್ಲಿ ರಸ್ತೆಯಲ್ಲಿರುವ BMW ಕಾರ್ ಶೋರೂಮ್ ಮುಂದೆ ನಿಲ್ಲಿಸಿ ನಂತರ
ಯಾವ ಕಾರ್ ಇದು?
BMW ಕಾರ್.
BMW.
ಸಲ್ಲಿಸಿರುವ ಏರ್ಲೈನ್ಸ್ ಹೋಟೆಲ್ಗೆ ಹೋಗಿ ಟಿಫನ್ ತಿಂದು ನಂತರ 1:15 ಗಂಟೆಗೆ ಬಂದು ವಾಪಸ್ ನೋಡಿದಾಗ ಮೇಲ್ಕಂಡ ಸ್ಥಳದಲ್ಲಿ ನಿಲ್ಲಿಸಿದ ನನ್ನ ಕಾರು ಇರಲಿಲ್ಲ. This is the complaint. Kindly see the ink page number 22, my lordship. Charge sheet.
No, one moment. 420 ಗೆ ಮಾಡಿದಾರ ಆಮೇಲೆ?
First to 379, then 420.
379 is dropped?
Yes.
Why 420?
Kindly see my ink page number 22, charge sheet para. First 3 lines, my lordship. 2022ನೇ ಇಸ್ವಿಯ ಫೆಬ್ರವರಿ ತಿಂಗಳಿನಲ್ಲಿ ಕಬ್ಬನ್ ಪಾರ್ಕ್ ಪೊಲೀಸ್ ಠಾಣೆ ಸರಹದ್ದಿನ ಲ್ಯಾವ್ಲಿ ರಸ್ತೆಯ ಏರ್ಲೈನ್ಸ್ ಹೋಟೆಲ್ನಲ್ಲಿ ಸಾಕ್ಷಿ ಒಂದರವರು ಮರ್ಸಿಡಿಸ್ ಬೆನ್ಸ್ ಕಾರ್ ನಂಬರ್ ಸೋ ಅನ್ನು ಕಾಲಂ ನಂಬರ್ 12ರಲ್ಲಿ ನಮೂದಿಸಿರುವ A1 ಆರೋಪಿತನು A2 ಆರೋಪಿತನಿಗೆಂದು 30 ಲಕ್ಷ ರು ಹಣಕ್ಕಾಗಿ ಸಾಕ್ಷಿ ಒಂದರವರಿಂದ ವ್ಯಾಪಾರ ಮಾಡಿಕೊಂಡು ಬಾಕಿ ಹಣವನ್ನು
10 ಲಕ್ಷ ಹಣವನ್ನು ಕೊಟ್ಟಿಕೊಂಡು ಉಳಿಕೆ ಆರೋಪಿತ 2. ನೀವು ಆರೋಪಿತ 3?
Yes, my lordship. I am the purchaser.
You have purchased it from whom?
A2.
So A1 sells it to A2, A2 sells it to you for 35 lakhs.
Yes, my lord.
ಅಲ್ಲಿ 30 lakhs ತಗೊಂಡು 35 lakhs.
Yes, my lord.
ಹಣಕ್ಕೆ ವ್ಯಾಪಾರ ಮಾಡಿ 15 ಲಕ್ಷ ಗೂಗಲ್ ಪೇ. ನೀವು ಯಾವ ಪೇಮೆಂಟ್ ಹೆಂಗ್ ಮಾಡಿದ್ರಿ ನೀವು?
Online payment, my lord.
ಆನ್ಲೈನ್ ಪೇಮೆಂಟ್ ಮಾಡಿದ್ದೀರಾ?
Online payment.
35 ಲಕ್ಷ.
No, 15 lakhs I paid.
ಇನ್ ಮಿಕ್ಕಿದ್ದು?
Mickey pending, my lordship, because of demand for documents from A2 vehicles document. This is the payment, my lordship.
ಅದೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ? ಕೊಡಿ. Who is A2 complaint is served unprecedented? ಇದರ ನೋಟಿಸ್ ಆಗಿಲ್ವಾ? ಫಸ್ಟ್ ಟೈಮ್ 23 ಇಂದ ಬಂದೇ ಇಲ್ವಾ ಕೋರ್ಟ್ ಮುಂದೆ?
2 times ಬಂದಿತ್ತು. 1 time absent.
Office objections.
1 time office objection, 1 time absent.
3 years you've taken to comply the office objections. ಏನ್ ಮಾಡಿದ್ರಿ ಕಾರ್ನ ಈಗ?
ಸೀಸ್ ಆಗಿದೆ ಮಲಾಡ್.
ಸೀಸ್
ಸೀಸ್ ಆಗಿದೆ. ಒರಿಜಿನಲ್ ಓನರ್
ಯಾರು ಅಂತಾನೆ ಗೊತ್ತಿಲ್ಲ.
ತಗೊಂಡಿದ್ದಾರೆ ವಾಪಸ್, ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ, ವೆಹಿಕಲ್ ರಿಲೀಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಅವ್ರ ಹತ್ರನೇ ಇದೆ ಈಗ?
ಅವ್ರ ಹತ್ರ ಇದೆ.
Government.
Accused number 3, my lords, received the amount from through the account of wife of.
Anyway, notice ಆಗಿಲ್ಲ ತಾಳಿ ಬರ್ಲಿ. 1 HCGP, 2 emergent notice, returnable in the second week of February.
Stay minute.
ಏನ್ ಸ್ಟೇ 3 ವರ್ಷ ಆದ್ಮೇಲೆ ನಾನು ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೆ. ಫಸ್ಟ್ ಟೈಮ್ ಆಗಿದೆ, ಅವಾಗಲೇ ನೋಟಿಸ್ ಮಾಡ್ತಾ ಇದ್ದೆ. ಎಸ್
47.
For petitioner, my lord.
Press
time for
Press
argument.
time, no grants time.
Senior
Yes.
is in out of station.
Out of station. What is the matter? Ashu Surendranath.
Please, Lord, now T. Manjunath judgment has come, Lord. In this matter, I have not filed objection. It is ready, my Lord. Can leave it on next.
ನೀವು 3 ವರ್ಷ ತಗೊಂಡಿದ್ದೀರಾ objection ಹಾಕಕ್ಕೆ?
Otherly, by mistake.
Eleventh Council Prasanna Shetty appearing for the respondent Lokayukta seeks 2 weeks time to file statement of objections. This court on the coordinate bench of this court on 7/12/2023 had passed the following order. Interim order was granted following the judgment of the apex court in the case of Ashu Surendranath Tiwari. The learned council submits that there is a change in law today and would place the same before the court on the next date along with a statement of objections. List on 20th. Objections, if any, by then.
Please.
Yes. Next.
I'm a proxy counsel in this matter.
Ah.
The counsel is held up in other court, my lords. Kindly short date.
Well, he'll be held up there only, is it, till the next date?
No, my lords, he's busy after that.
Busy advocate.
No, my lords, he has some personal inconvenience, that's it. Any date, my lords.
7980 KPI.
180.
Permission ಎಲ್ಲಿ? ಅದು ಬರಲ್ವಲ್ಲ.
ರಿಕವರಿ ಇದೆಯಾ ನೋಡಿ. ಚಾರ್ಜ್ ಶೀಟ್ ಬರಿ ಎಡ್ಡಪ್ಪ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿ. ಬರಿ ಒಂದೇ ಒಂದು ಪೇಜ್ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿ.
ಕಾಗ್ನಿಸೆನ್ಸ್ ತಗೊಂಡಿರೋದು ಯಾವುದಕ್ಕೆ?
188 ಮತ್ತೆ
195 ಬಾರ್ ಇದೆಯಲ್ಲ. 188 ಬಾರ್ ಇದೆ. ಇವೆರಡಕ್ಕೆ ಪರ್ಮಿಷನ್ ಇಲ್ಲ, ಎಲ್ಲ ಕ್ಲೋಸ್.
188 ಗೆ ಕಾಗ್ನಿಸಬಲ್ ಅಷ್ಟೇ. Permission is not needed. Only
ಅದು if you added it, ಅದು 195 ಇರಬೇಕು. ಅದು compliance with 195, 188 ಗೆ. There is no compliance for that. 7980 KP Act. Gambling.
ಕೋವಿಡ್ ಟೈಮ್ ಅಲ್ಲಿ ಎಲ್ಲ ಸೇರ್ಕೊಂಡು
ಇನ್ನೇನ್ ಮಾಡ್ತಾರ ಆ ಟೈಮಲ್ಲಿ?
ಅಲ್ಲ ಹಣಗಿನ ಇಟ್ಟಿದ್ದಾರೆ ನೋಡಿ.
ಬೇರೆ ಏನ್ ಮಾಡಕ್ಕೆ? It's actually covered by page 32. Same order, same offense, same COVID. ಅದು ಕುಪ್ಪರಾಜು, ಇವರು ನಾಗರಾಜು, ಅಷ್ಟೇ ಡಿಫರೆನ್ಸ್. ಸೇಮ್, ಇವ್ರು ಮಾತ್ರ ಪ್ರಾಕ್ಸಿ. Yes, we'll close it. The petitioner is before this court calling in question proceedings in CC 11756 of 2020 registered for offences punishable under section 79 and 80 of the Karnataka Police Act and section 188 of the IPC. The petitioner claims to be similarly placed and the period of offence also similar to one that is considered in criminal petition 1409 of 2023, which comes to be disposed on 21st February 2023. The offence therein was identical to what is alleged in the case at hand.